My lord, a fair price shop has been cancelled without issuing an inquiry report and without issuing the complaint petition filed against me. So it may kindly be listed on Monday.
Motion.
No, it is earlier it was ordered that it should be listed after 3 weeks, but 3 weeks have already passed. Not listed, but since last 8 months I am out of the shop for no legal reasons.
So what is the difference between in 8 months and 9 months?
Difference is this, my lord, that is the source of my income, my lord. Some commission I get and thereby I earn my livelihood.
But the problem is
No, court's order was that it should be listed after 3 weeks. So that is not listed. That's why, my lord.
Monday. There are already 45 matters listed. Apart from that, new motions are going to come. How can I finish?
Your lordship is well versed in disposing the matters.
I'm fast in disposing of the matters. First, the matter has to reach me.
Let me try my luck at this.
Okay, Wednesday.
But,
Must mean item number 42, we have filed an affidavit that may be called.
Wait, please, your lordship. Yesterday, lordship, one fishery matter is listed before this court, lordship. Lordship and allowed to be withdraw or liberty to file a case. Today, we refiling this matter, lordship. Refiling this matter, lordship. Lordship may pray for today.
Today? Absolutely no.
Lordship,
Monday.
tender accepted date, lordship, 22, next Monday, lordship.
You made a mistake. I was about to dismiss, but I was very kind enough allowing it to withdraw. I was about to dismiss with cost of 15,000. Then, let's see today. But no interim order. That's the fishery matter, na?
Yes, lordship.
Dibrugarh,
Yes, lordship.
where you say that 13,45,000 should not have been there.
Yes, lordship.
As per you, it should be
26.
4 lakhs at best.
Yes.
Or 2,80,000.
Yes, lord.
Okay, we'll have it.
May I please, your lordship? I beg to mention item number 48, lordship. In this matter, the main CRP has been disposed of, but 3 IAs which were filed for condonation of delay, substitution, and setting aside abatement, and no order has been passed and they were remain pending. That is why they have listed, lordship. So I pray that
These IAs for what?
IAs for condonation of delay, setting aside abatement, and substitution. But the main case has already been dismissed on withdrawal. But no order has been passed in this IA inadvertently.
AI ki khan likhi thi po? The council appearing on behalf of the applicant submits that as the main application being CRP number 422/2015 have already been withdrawn. Nothing survives in the instant application, and according so taking into account the above the said application stands closed on withdrawal. Separate.
May it please your lordship. With regard to item number 28, my lord, we are supposed to file an affidavit in reply, my lord, but petitioner is seriously ill, my lord. So she could not come to swearing her affidavit. So, my lord, after vacation, my lord, this matter may kindly adjourn.
Matter pertains to?
Pertains to regarding fair price shop, her late husband was allowed to run fair price shop, my lord. And after her demise of her husband, my lord, she is the only, this fair price shop is the only source of income of their family. And the petitioner's elder son, he is.
Is it hereditary?
No, not
Is the
hereditary,
fair
my lord.
price shop-
On compassionate ground, my lord. Only on compassionate ground.
Fellow, at the request of the learned counsel for the petitioner, matters stand adjourned to be listed after 4 weeks.
On any date, my lord.
4 weeks.
May I please your lordship, I beg to mention item number 32. Lordship, with the consent from the petitioner, may the matter be referred for mediation drive.
Oh, I don't do that. We'll see where the matter reaches as to whether it's a fit case for mediation. I don't do mediation business like next.
May I please, Your Lordship, in supplement list item number 55, we file an IA civil for impleading parties. This record is not tagged with the case record.
Hmm?
That maybe kindly call for me.
Okay.
Supplementary item 58, state 10:30 AM.
Yes, Mr. Chaudhary. what
Well,
do you-
they have agreed. My young friend has received a mail. This is of course subject to fulfillment of other conditions.
Yeah. Or Mr. V.K. Das, the learned counsel appearing on behalf of the petitioner, Mr. I. Chaudhary, the learned senior counsel, it's assisted by Mr. P. Sharma, appears on behalf of the respondent of the 1 and 2. This court, by an order dated 18/9/2025, inquired with the learned senior counsel appearing on behalf of the respondent number 1 and 2, whether in the present case, the petitioner can be given a further opportunity by taking his financial documents, subject to the petitioner being eligible in respect to all other parameters of the tender document. Full stop. And accordingly, had fixed the instant proceedings date. Mr. I. Chaudhary, the learned senior counsel, had produced an email dated today,
So-
na? Email dated today,
It's today.
email dated, dated 19/9/2025. Issued by the DGM desk contracts on behalf of the CGM desk contracts bracket HOD of the respondent number 1, wherein the respondent number 1 and 2 are willing to, I'll put my words better than this is not so clear. Are willing to provide a further opportunity to the petitioner by taking his financial documents, subject to the petitioner being eligible in respect to all other parameters of the tender document. Full stop. The said document, the said email is kept on record and marked with the letter X. Mr. B.K. Das, the learned counsel, submits that the petitioner, in view of the stand being taken by the respondent number 1 and 2, does not have any further grievance. Full stop. Taking into account the above, the instant writ petition therefore stands closed, directing the respondent authorities, more particularly the respondent number 1 and 2, to accept the financial documents of the petition, which were submitted by the petitioner on
My lord, 10/2/2025,
It was,
an email on 20/2/2025.
10/2, we did not receive it. Our instruction is 22.
Yes,
20/2/2025. And the respondent shall duly consider the bid of the petitioner, keeping in mind that the petitioner is otherwise eligible in respect to all other parameters of the tender document. The petitioner stands on.
now obliged for intervention this matter.
Top of the list item 19 to 23.
What
My
is
lord,
your
certain
instruction?
deliberations have taken place. We are willing to discuss it more with them. What has happened? They are agreeable to a issue that they want to charge us simple interest to a period. After that, they want compound interest.
No, no, Lordship, that's not the point. They have agreed to pay us as per the MSME Act up to 2019. 2019. And for the rest of the period, they say, will you accept 12% simple interest per annum? That is the point. Lordship, we are more or less, Lordship can.
Madam, no, last time when you made that submission to me, you were agreeable till 2019.
19.
Leave aside the other things.
Yes,
Get your instruction, leave aside the other things. Till 2019 is also a fair amount.
fine, Lordship. Let them pay till 2019 and we'll discuss later.
I have instructions from the authorities that they want to further deliberate the matter. They want to call for a second meeting, my lords. One meeting has been,
Have it,
my lords.
you have a meeting, there's no quarrel. I'm only telling, because last time a submission was made before this court.
My lords.
The petitioner is okay till May or 2019, which was the amount which was
My lord.
already given in that order. Petitioner was okay with that amount.
My lords.
They would not further like to go beyond that, means 19. Beyond that, otherwise the amount goes phenomenally high.
My lords.
And the problem is, if I have to adjudicate, the order comes very strongly against
I
you.
understand.
Therefore, I gave an opportunity. And the madam was very kind enough to look into that and advise her
Right.
clients in that regard. My only earnest request to madam is, keep till 2019, which you have already, they have done it till 2019, and you also finalized on that.
My lord.
Don't go further, because if you are any further, if you go out there, then if there's no agreement, there is a big problem out there, which I have duly noted in my earlier order also. Have a look at it, finish it up. We have it after,
My lord, after vacation, my lords.
we have it after vacation on 15th of
15th.
October.
My lords.
Yes, until 2019, they're clear in the meantime.
Because
No,
till,
no.
my lords.
On 15th of November,
My lords.
October,
My lords.
you come up with the proper thing and you agree and enter into some settlement and come up and we.
Absolutely.
Okay,
Fine.
that is the fine.
My lords. Because
Because I don't want to go beyond 19. After all, we are also concerned. We know that the state is very benevolent in spending money right, left and center. But then also it is after all the public money.
My lord, what I was asking the authorities, not just a commitment that we will pay. I was asking the timeline also.
Yes,
Because,
exactly.
because after that contempt will follow.
No, they have to enter into some form of negotiation or agreement.
My lord.
Place it before this court.
Yes, exactly.
And this court will put it as a stamp of authority, meaning thereby you are bound to pay that.
My,
It will be more like a compromise degree.
my lord.
And failure to do so would be contempt.
Fine. Lordship, 15th of October.
It has heard Mrs. M. Hazurika, the learned senior counsel, appearing on behalf of the petitioners, as well as Mr. D. Gogoi, the learned counsel, who appears on behalf of the PHE department. It has been submitted by the learned counsels that in pursuance to the order dated 9/9/2025, there has been certain deliberation going on between the petitioner and petitioners in the batch of writ petitions with the special secretary of the PhD department.
Special chief
secretary.
Huh?
Special chief secretary.
Additional chief secretary.
Special chief.
Special chief secretary.
It is something like that, nah? Chief. We have heard of chief. Then we have an additional chief.
Now we have a,
Then we heard of a special. Now we have a special chief.
absolutely.
It is something like a senior additional advocate general or something. Okay. Special chief secretary of the IMAN, and there is a likelihood that the matter can be amicably resolved. So taking into account the above, list this matter on 15th of October 2025, showing it as part of.
Absolutely.
For motion item 1,
May I please your lordship?
Yes,
Here, my lordship has asked me to file an additional affidavit, and I have filed an additional affidavit. This pertains to with regard to non-payment of the contractual bill, my lordship. My lord, the impugned order is at page 57, the last paragraph, my lordship.
where is that order?
My lordship, it starts from page, my lordship, 56, the relevant portion, page 57, my lordship.
When did you give it?
My lordship. Annexure 8, page 59, my lordship. Page 59. My lordship on last occasion has heard this matter, and my lordship has directed to file an additional affidavit. As according to my lordship at page 58, my lordship has stated that since the direction was given to the chairman Bipuria Municipal Board to take steps to grant of approval. And so with that regard, I was asked to file an additional affidavit in which I have stated clearly that approval was not yet given, my lordship, and for which my lord, the executive officer has not paid the amount, my lordship.
So the approval has not been granted.
Not granted yet, my lordship.
So you have made only here, no? Dipchika Bora,
Yes, my lordship, because
the chairman.
my lord.
Issue notice making it returnable on 17th of October 2025. Steps be taken upon the respondent or respondent by way of speed text. In addition to that, the petitioner is also given the liberty to take steps by way of dusty routed to the registry of the court and file an affidavit of service on or before the next date. The case of the petitioner here, the petitioner herein is aggrieved by the willful and deliberate violation to the order dated 26/5/2025, passed in WPC number 224/2025, whereby the chief executive officer, whereby the chairman of the Bipuria Municipal Board was specifically directed to take all necessary steps for grant of an approval for payment of the admitted amount to the petitioner. And that too within an outer limit of 2 weeks from the date of receipt of the certified copy of the order. The materials on record show that on 30/5/2025, the copy of the said order was furnished to, was served on the respondent. However, as no steps were taken for approval, the petitioner being aggrieved with the approval, it is the case of the petitioner that the action on the part of the respondent amounts to willful and deliberate violation to the orders passed by this court. The respondent is directed to bring on record its stand as to whether not granting of the approval as directed by this court by order dated 26/5/2025. As to whether the order dated 26/5/2025 passed in WPC number 224/2025 have been complied with or not. You take dusty service
My lordship,
along with the copy of the order.
my lordship.
I think that will
Obliged.
be enough.
Item two,
May it please the lordship, but this is a contempt petition, my lord, whereby you have alleged violation of your lordship's order dated 13/5/25, my lord, pertaining.
You have filed an additional affidavit?
We have filed, my lord.
What does it say?
Kindly come to,
Where is the order?
Please.
copy?
my lord, may kindly come to page number 29, annexure 3 of the additional affidavit, man.
Huh?
My lord, may kindly come to annexure 3, page 29 of the additional affidavit.
What is the direction? Where is the order?
Order starts at page 14, my lord, and the operative portion is
Order
at
passed that date.
14, my lord. And operative portion is at page 17. Sorry, page 16, my lord. May I read paragraph 5, my lord?
Finance. Where is finance and? Finance has been directed. Where is finance department here? The council tell me, how can this order be complied with, taking into account that the finance is not a party in the requisition?
My lord, may I kindly come to paragraph number 5 of the order, my lord. It is only the respondent number 5, that is the district commissioner Dismissal, who has to comply with the order, my lord.
But without the finance being made a party, how can they be? If the finance have not done it,
So, finance has approved and sent it, my lord. Only the disbursal part was,
there's a direction at paragraph 7. All the response, EC has given the finance is directed to revalidate the ceiling. So whether the revalidation has been done,
uh, uh,
without revalidation, there cannot be a payment. How do you get an order? Means, how do you enforce this order?
my lord, when this petition was heard, my lord, the
Very well, I understand. But the fact is, yes, appears to be some mistake. But without the finance being a party, how is it possible? Now, can you see, if a direction is made to payment, means he has to make the payment. How will he make the payment if the finance is not revalidated? Now, the finance is not a party there.
my lord, the finance department was heard at the time of
There's no finance. 4 and 5. 4 is chief engineer and 5 is executive engineer. And this is where, not Kachar, MC Hills,
autonomous council.
deputy commissioner, who is to directed to pay? Yes. Madam, you take it up in instructions in this matter as to whether the order passed by this court dated 13/5/2025 had been complied with.
Mhm.
This court have requested Miss Udas, Mrs. Udas, the learned
Additional-
senior government advocate, to obtain instructions from the district commissioner, Dimahasa or Haflang, as to whether the order dated 13/5/2025 in WPC number 453/2025 have been complied with or not. To list this matter again on 26th of September 2025. A copy of the application, a copy of the present application be served upon Miss Yuda, so that the learned additional senior government advocate, so that the learned counsel is in a position to obtain instructions during the case, during the course of the day will depend. First of all, the registry shall show the name of Miss Yuda in the cause list.
item three,
Obliged.
May I please your lordship? The petitioner
has filed this contempt petition, that respondent Air India Authority were just buying the time, your lordship. So the petitioner compelled to file these petitions as they were not complying till
Which order?
lordship. The order is at page number 9, your lordship.
What is
9
the
to
direction?
9 to 18, your lordship.
Huh?
9 to 18.
Who are you? Air India.
Air India, lordship. I am for the petitioner, contempt petitioner, lordship.
Contempt petitioner mean Suresh Baspor.
Baswar, yeah,
You are a workman.
lordship.
You were a workman.
Yeah, lordship.
An award was passed.
Lordship.
Against this, there was a challenge.
Challenge, they have made the challenge.
The writ petition was dismissed.
Lordship.
Then why are you here? Why don't you go for execution of the award as per the Industrial Tribunal, the Industrial Disputes Act? It's much more efficacious.
Lordship.
Yes.
Even then, lordship, that this order, this court was pleased to pass the order and dismiss their writ petition. Your
Understood.
Lordship.
So therefore, that award which is there is required to be put to execution. Industrial Disputes Act 1. You have not looked into that.
Lordship, yes, as per section 17A of IDF, lordship,
Ah.
this award is enforceable,
Yes.
lordship,
Then go there.
after 30 days of the award, lordship.
Therefore, after the judgment, after 30 days,
Lord.
you file an application. These people can be imprisoned there. Immediately they will do it.
Lordship. But
You see, the
Lordship.
contempt does not arise out here. Here the court had dismissed the writ petition. There is no direction passed that it is going to enforce the award.
lordship.
No case. You withdraw, file there. 17A. Oh, yeah.
An observation may be made, your lordship.
I will say that you have submitted.
Lordship.
The learned counsel appearing on behalf of the petitioner submits that by virtue of the order, judgment and order dated 12/9/2024, passed in WPC number 5069/2016. The writ petition was dismissed. Thereby, the award dated 30/10/2015 passed by the Central Government Industrial Tribunal cum Labour Court Guwahati in reference case number 5/2011 have been confirmed. He therefore submits that the petitioner would be well advised to initiate action under section 17A of the Industrial Disputes Act 1947. Rather than
enforceable.
Proceeding with the instant proceedings. So taking into account the above, the instant contempt proceedings application stands closed on withdrawal. However, liberty given to the petitioner to take appropriate steps under section 17A of the Industrial Disputes Act 1947 before
Or any other provision, lordship.
or any other provision of law. It is given the
IDF.
liberty given under section 17A of the Industrial Disputes Act 1947 to take appropriate steps for enforcement of the award or enforcement as well as also for enforcement of the. It is further observed that the petitioner shall also be at liberty to resort to other remedies other than the contempt, initiating the contempt jurisdiction of this court for enforcement of the award.
Obliged, lordship.
Item 4.
Obliged, lordship.
Directed to strict instruction.
My up-to-date instructions are awaited, my lord. Up-to-date instructions are awaited. Though I've received something, my lord,
You've got the instructions?
but it's not complete, my lord.
How many? Would it take years? Where is it? Subdivisional engineer, Nogao,
My lord.
very far. People can walk to Nogao, get the instruction and come back from the last time. Don't you think so? Then, 2 o'clock.
I'll try my best.
See? With 10,000 rupees cost upon that engineer for not providing. What is your case? We'll pass a stay order, they are not coming. As to why the respondent authority shall not be directed to install electricity connection owned by the petitioner against consumer respective.
Wrong consumer number, Lordship.
Huh?
These are not our consumer number, Lordship. It is a neighbor's consumer number, but notice was issued against us. Lordship will find the notice at page 12, Lordship. I'm Anil Hazarika and Pranav Hazarika, Lordship.
Page 12.
Page 12, Lordship.
Your name is?
My name is Pranav, my name is Lordship Anil Hazarika, Anil Kumar Hazarika.
Anil Hazarika and Pranav Hazarika.
Pranav Hazarika.
And your consumer number is ending with 44819 and 44910.
Lordship.
Payment of outstanding.
That is Lordship.
In your name premises bearing consumer number
PI number
155 amounting to 1,80,700 remain. What is this number?
This number is belong to Lordship Prabhat Chandra Hazarika, Lordship. That
Who?
Prabhat Chandra Hazarika, Lordship.
Where is he?
Lordship will find
Inform you that you have a huge outstanding bill against the electricity connection in your name premises bearing consumer number 20. And they have disconnected your electricity.
Lordship, I have disconnected
Ah.
electricity, Lordship.
Restore it. Forthwith. It was disconnected when?
Lordship. Only
2024.
23, my lord, August 23.
That
After we have filed representation, Lordship. Lordship will
nothing has been done. Without electricity, you are running.
Lordship. Page 16 to 22, 16, Lordship.
Well,
Page 16, Lordship.
We
And
dispose it of.
Hmm.
We dispose it of giving, thereby directing you to not to disturb them here and restore the electricity.
Lordship, perhaps not disposed of. We'll restore the electricity connection. What I've received my instruction that the Prabhat Chandra, the one Prabhat Chandra, he was the earlier occupant or the owner who has the pending dues, my lord.
So he has a different consumer number.
Yes, my lord.
So you disconnect his electricity. Why them?
No, my lord. Presently, he's not staying there. They are the new owners.
Understood. Why have you issued a different consumer number to these people?
That instruction is not complete.
So
That's
does
why
it
I've
take
asked
for you to ages for getting it? And Mr. Counsel, very horridly drafted petition. You should have asked many more reliefs. What is your relief? See? In the premises, it is hereby prayed that your lordship would be graciously be pleased to admit this petition, issue notice calling upon the respondent to show cause as to why the respondent shall not be directed to install electricity owned by so and so. खत्म हुआ? Electricity bill. This is again, your consumer number is what?
I have annexed a bill.
This is for Prabhat Brothers. Prabhat Brothers transaction amount is 1,000. And then for AK Hazarika is 1,000. Then what about the others?
Others, I'm not for the others, Lordship. Only Pranav, this Anil Kumar Hazarika and Pranav Hazarika, Lordship. I'm not for others, Lordship.
But you have not enclosed their bills.
Lordship, I have not enclosed because I have enclosed only Lordship Anil Kumar Hazarika and Pranav Hazarika.
Mr. Counsel,
Lordship.
you are for Anil Kumar Hazarika and Pranav Hazarika.
Lordship.
So where are their bills?
Okay. My next one, bill also, Lordship.
You have enclosed the bills of somebody else. Kindly come to Annexure 2, page 12.
Lordship.
Anil Hazarika's last is 44819.
Lordship.
Pranav Hazarika's last is 44910.
910.
Okay.
Well done.
AK Hazarika is 10610.
Okay. Lordship.
Prabhat Brothers is 10608.
Lordship.
Okay.
Okay.
Now kindly come to annexes page 23 and 24. Here the consumer number is whose? For whom you are not appearing. Then how can I help you? Not properly. You should have enclosed his bill. Have you got, you get a bill, I suppose.
Okay.
Then why haven't you got the bill properly? I think you should do it properly. Properly draft your petition, bring those bills, and come back. Can you do it next week? File a proper petition. Otherwise, you never get it. Bring those bills of Anil Hazarika and Prabhat Hazarika. That's it. Issue notice making it returnable on 3rd of November 2025. See, you are enclosing page 8, AK Hazarika. Who is AK Hazarika? He is different. He is not the petitioner.
Lordship.
Issue notice making it returnable on 3rd of November 2025. Mr.
B does, my lord.
accepts notice on behalf of respondent numbers 2 and 3. SR Borwai appears on behalf of respondent number 1.
Item number 4.
The case of the petitioner herein is that the petitioner are consumer of electricity by the respondent number 2 and 3, provided by the Assam Power Distribution Company Limited. The consumer number of the petitioner are of the petitioner number 1. The petitioner number 1 has been provided with 2 consumer numbers bearing consumer number 1220100444819 and 122 cited 10610. And the petitioner number 2 is being provided with a consumer number 12201044910. On 21/9/2023, a notice was issued by the respondent number 2 informing the petitioners herein that there is an outstanding liability in connection with of an amount of rupees 1,80,717 in connection with consumer number 122 cited 13155. And it was mentioned that the petitioners consumer number electricity connections would be disconnected. The petitioners have submitted representations stating that they are not involved in respect to the consumer number 122 Cited 013155. And as such, the said outstanding amount should not be imposed upon them. However, the said representation was not taken into account, and the petitioners continue to remain without electricity. Since then, it is under such circumstances the present petition has been filed. This court, by an order dated 27/8/2025, sought for instructions from the Standing Council of the APDCL as to why the petitioners' electricity had been disconnected although almost a month had passed. But the respondent number 2 have failed to provide the instructions, and it is under such circumstances this court is taking up the present proceedings as to whether any interim directions are required to be passed. The materials on record show that materials on record as well as the statements made by the petitioner by way of affidavits show petitioners that the petitioners are nowhere connected with the consumer numbers 122 444 000 cited 13155. And as such, the question of disconnection of the electricity to the consumer numbers provided in respect to the electricity connections relating to the of the consumers, relating electricity connections of the petitioners pertaining to the consumer numbers. Consumer side number did this, na 44819 so and so 10610 does not arise. Under such circumstances, this court is also of the opinion, and this court is also aware, conscious of the settled position of law that the electricity being a necessity, the respondent authorities cannot disconnect the said electricity if dues are not payable by the petitioners. Considering the above, this court therefore directs the respondent number 2 and 3 to in the interim to reconnect the electricity in respect to consumer numbers 44819 44910 10610. Subject to payment of the necessary electricity dues.
Some may be shown in the causes.
You are otherwise not going to say anything. Not necessary. But Mr. Counsel, first of all, you have to know how to draft the petition. APDCL have to be made a party. I've been very considerate enough to pass this type of order. In fact, this petition should be thrown. I'm taking it as a letter petition, not as a writ petition. Next time be careful. Yes, Mrs. Saikya, what is this?
Regarding releasing of BG, my lord, paragraph 3, I have stated that my lord, a BG was
Who has not
executed by
released the
the
Pengarang? You have.
On behalf of Canara Bank, in
Paragraph-
fact, whatever, Lordship, this BG was invoked by the NF Railway, Lordship. Before we could honor the Lordship BG amount, Lordship petitioner approached this honorable court. And there is an observation that, Your Honor, encasement of the BG and the termination of the petitioner will be subject to outcome of the writ petition. And Lordship, that writ petition
But
was
my lord,
finally.
may I submit my, that
I will-
BG was long back, it was expired, my lord. expired on 26 December 2021. What happened, my lord? The contractor, the petitioner, he is a contractor. He executed 3 work in the railway. In the 4th work, he got the payment also, and smoothly everything was executed, and he got the payment. In the 4th work, there's some dispute because after allotment, the agreement was signed 2 years after 2 years, 4 months. Agreement. After the agreement only he can start the work. So some dispute arises, and my lord, the dispute is at present, my lord, before the arbitrator,
Between?
between the railway and the contractor. Before that, he has executed 3 works successfully. And the 4th work, when that allotment was given, but my lord, agreement was not signed by for 2 years, 4 months. Thereafter started, then my lord, lockdown came, this, that, my lord. So everything, it is before the arbitration tribunal now. The BG is expired long back in the, my lord. 26 BG was given for
Where is the BG?
BG at page number. Agreement is page number 21, my lord.
It is not a BG, it is some Kamdhanu deposit general, deposit receipt.
Yes, or not?
That
In
is
the
the
BG.
copy I have given in page 25, my lord.
Arunachal Pradesh to, yeah,
It is expired on
Yeah,
26th of December
so
21.
request the demand to so 48 lakh. So, no, and but I need a guarantee at intel in court. Of the government. So, madam, kindly
Yes.
come to page 23,
Yes, ma'am.
paragraph 3.
Page?
Page 23, paragraph 3.
Yes. Yes.
Yes, read it.
Canara Bank, Pasikat branch, so and so, market possible, so to Arunachal Pradesh, so and so, agree that the guarantee herein continued shall remain in full force and effect during the period that would be taken for the performance of the said agreement, and that in it shall continue to be enforceable till the dues of the government under or by virtue of the said agreement have been fully paid and claims satisfied or discharged, or till chief engineer construction NF Railway Maligaon Guwahati Assam certified out by the said contractors, and accordingly discharge the performance guarantee unless a demand or claim under this agreement is made on us in writing on or before. It is important, my lord. 26th of December 2021, we shall be discharged from all liabilities under this guarantee thereafter.
Now, when was the demand made?
Demand, they have not made any demand.
No, no, obviously demand must have
Yes,
been made.
Lordship, I think,
Okay.
Lordship, the demand for invocation of BG was made on 15/12/2020.
So it is much prior to 26/12.
Yes,
Page
but
7.
Honorable High Court has
26,
passed some
12.
order also, my lord.
Huh?
This High Court has passed some order also. I have
Where?
orders enclosed here.
Where is the order?
Passed, yes, my lord. You got answer, please. First order was, my lord, at
However,
page
it was
28.
made clear that the so and so departing the area is or
Yes, no. Yes, no. Demand.
subject to the outcome.
Page 7.
So it is said subject to the outcome, no stay.
No stay.
Okay, then what happened?
Thereafter, my lord, again, my lord, the case was
Again,
disposed
the
of.
matter came up
Case was
before this
disposed of,
court,
that is
then what did the
33.
court do? In the event of any approach by the hereby filing representation. No, in view of the affair, it is may approach the appropriate authority in the respondent for redressal of a pertaining to the issues involved. After considering the said representation of the petitioner shall dispose of the same at an early date. So no order on the BG.
No order on the.
Then again
Thereafter,
another
my lord,
petition filed.
another order, yes, my lord, for
Another
arbitration.
petition filed,
Page 36.
page 35.
36, my lord, is the relevant.
Uh,
Last paragraph
On
in
the
view of the
other,
said
order of termination was passed when so has submitted without taking into the relevant fact the order has been mechanically and so has also obtained that the bank guarantee dated is likely to be encashed. Yeah, on the other hand, Keiko appears that this record has submitted the order has been in the public interest. That go to work order was
Security deposit for the time.
in the dismissal again, nothing remains. Then
Yes,
bank
my lord,
guarantee
but
invoked
whether
when did you invoke the bank
Lordship,
guarantee?
bank guarantee was invoked by NF Railway on 15/12/2021, page
When
7.
did you disburse?
Lordship, before we could Lordship release the amount, the petitioner approached, before we could Lordship release the amount in favor of NF Railway, Lordship petitioner approached this honorable court.
But
So,
there is no stay.
Lordship, but there is a direction that
Anyways, then
encashment of the bank guarantee and the termination of the contract will be subject to outcome of the.
anyways, what has happened thereafter?
And thereafter, Lordship, then second round of litigation, Lordship, there's a direction that Lordship, that the matter need to be adjudicated by the arbitrator.
Arbitrator.
Until then, Lordship,
Now why is the petitioner agree?
Lordship, petitioner is agreed because she wants to, Your Honor, take away the security deposited that is given
Why
in
the
connection.
railways? Nobody is appearing for the railways. You have not served copy.
railway copy sub, I think, man, and the clerk copy railway design.
Madam, you cannot make. You have to make the NF Railway a party.
I've made the
Where?
party,
Where is NF Railway a party?
external court, performer dependent.
Show me. Read it. General Manager Construction is the NF Railway. That's
General
zero
Manager
affair.
Construction.
Madam, this is not a case by which earlier council I allowed it, but here you are asking for these are proper litigation.
General Manager
party.
Construction is the authority,
The
my lord.
court is not going to allow this type of
Whole
petition
department
to
I
be
did
filed
not-
with the NF Railway has
Uh,
not been made a party. No case. Because
My lord,
what you are asking here is that the amount which is lying with him
yes, my lord,
be returned to you.
yes.
Though NF Railway has already invoked the bank guarantee,
And
meaning
after
thereby
expiry-
if I pass an order, NF Railway will be affected.
NF
And
Railway, my
NF
lord,
Railway is not made a
after
party,
expiry,
proper
whether
property.
After expiry, my lord, they can
That case,
invoke their right. After,
madam, I give you a good opportunity. From 7th of November, I may not be here. You may have this motion after 7th of November, not prior to that. Prior to that, the matter comes.
I'll serve
The
a
case
copy, my
for
lord, already
no,
copy served,
it's
my
a
lord.
case for dismissal right away without a notice. This type of cases, first of all, you have not made NF Railway a party.
Because dispute is between the bank and.
No, it
petitioner.
cannot be
No,
between you and the bank. Can the bank today, can this court direct the bank to make the payment when there is an arbitration proceedings lying between you and him? Secondly, the NF Railway is justified to get that amount. Now, whether you are entitled to the refund of that, that is another aspect which is the subject matter of an arbitration proceedings. But all said and done, that NF Railway is an essential party out here. You have not made them a party. No case.
Four,
Case
response
for
number four,
dismissal.
my lord.
There might be a
So, my
kinder
lord,
judge.
if your lordship, my
on-
lord, I can implement and file an
Madam,
impleading petition, my
the
lord.
kind judge is coming on 10th of November.
7th of.
10th of November. Then
And
he
if-
may issue a
If
notice.
your lordship, the whole department is.
No,
made party,
that
then
case.
I'll file an impleading petition.
Okay, you go to the division bench. Let me dismiss it right away.
No, my lord.
Yes.
That is not be proper,
No,
my lord. That
I'm
is
not
not be
going to issue
proper.
notice this type of.
Okay, let it be on 10th of November. I have
10th
no
of November.
objection.
At the request
I'll
of the
file-
learned counsel for the petitioner, matter sent adjourned to on
October, date
Again,
given in October.
back to me.
Yes, sir.
10th of November. October again, same thing. 10th of November.
No, because I will file and my lord, impleading petition, pleading all the my lord, say
Okay,
them, everybody.
so,
party.
Mrs. N. Saikia, the learned counsel
Impleading-
appearing on behalf of the petitioner, submits that she would like to file an impleading application in the instant writ petition. Taking into account the above, list the matter
On
upon such
25th.
application is filed.
Yes, ma'am. Can it be fixed on 25th? Before vacation, just
I
25th.
can't. The moment you file, it will come.
After expiry, there are so many decisions, my lord. After expiry, they cannot. take-
Decisions, you see, Supreme Court is there, help you out once it goes from here. Yes, NRC. Who is appearing for this? This is a devoter.
Yes.
How many rounds? First round, second round, how many rounds?
First round, my.
First round.
First round. Mr. Paying, there is one matter. I
Yes,
think
ma'am.
it is fixed
Yes,
today.
yes, yes, yes. Yes, my lord. I got the
It's
information.
fixed on 26th.
26.
Yes,
Get your
ma'am.
instructions.
Yes, yes.
How many times a person, that is why I'm asking you, how many times this is? First time.
First time, yes.
First.
Okay, when was your devoter marked?
Lordship,
2005.
2005.
2005.
5.
Voters list. Constituency.
Lordship,
SP border. Which one?
Golpara.
Voters list where?
Voter list of my lord, Choleshwar constituency.
Disposed. Disposed.
When?
You provide the number. Voters list. Constituency.
May I please, Lordship?
Yes, Mr. Mahmood.
My lord, petition number 1 is the panchayat and 2 is the president of the panchayat, my lord. Now, my lord, as
Before
per-
that. Madam, tell me one thing. Yes, you. Tell me one thing. Whether Assam or the central government have made any rules in respect to the Inland Vessels Act 2021?
Yes, my lord.
You provide it to me because I require it for that CAV judge.
My lord.
Yes, next.
Lordship, I'll provide.
Yes, provide it to him.
Now, my lord, as per 107, section 107 of the Panchayat Act 1994, the arts, ghats, etc. within the jurisdiction of the panchayat shall be settled by the panchayat. Now, the two parghats here that Lordship may kindly see, is Basbari Bajar Parghat and another is
Basbari.
Salavila Bandaras Singer Parghat.
What?
So kindly see page 14 and 16.
16 is what?
16 is the picture of that bamboo bridge, which has been
Both have bamboo bridges.
both are bamboo bridges. That means during the time of winter, my lord, bamboo bridges are used, but during the rainy season, at that time boats are used. It is not parghat, it is only ghat only.
Okay.
Now, my lord, as per section 107 of Panchayat Act, the such type of ghats, which has less than 2,500 tender amount, those should be settled by the panchayat by calling NIT. Now that NIT was, my lord, called for this year also. Can we see this? But we have been restrained
from
calling a NIT and settling the market to the persons on the basis of NIT. And the respondent number.
No. 107 you are referring to.
Section.
107 is something else to do. No private ghats, fishery.
Settlement of
Allowed to
private
be-
ghat and fisheries by Gaon Panchayat.
No, Mr. Mahmood, that section has already gone. No, that section is no longer there. It is no longer there after 2023.
But even then in practice, can you see that?
No, forget about practice. We are not on practice. We are concerned with the provision. If you are relying on 107, 107 no longer remains. Have you seen 107 as it exists today?
That is, but here in the.
No, that book has gone old. 107. Down below.
Yes, no private ghats and fisheries shall be allowed to operate within the area under the jurisdiction of a Gaon Panchayat without prior approval of the concerned panchayat authorities and government. The panchayat shall impose such fees as may be prescribed. So panchayat's power have not been taken as a whole. So panchayat has issued NIT.
No, these are private.
Private, these are private ghats.
Understood. If these are private, how can there be a private over the river?
About the river
Means on both sides, it's a private. Have you taken the permission from the government?
permission is, my lord, that is impliedly given.
No.
Kindly said,
No
because in
implied.
the last year also, this year also we have called NIT. And copy has been forwarded to Chief Executive Officer, Bongaigaon Jilla Parishad, the Executive Officer, Block Development Block, and the Inland Water also. This is the, all copies have been sent to all concerned.
Okay, then what?
Now, my lord,
Hmm.
this time also, that is for the financial year of 2005, 2025, 2026.
Hmm.
We called the NIT for several ghats, including these two ghats. Now, the respondent number 4 and 5, they say that as per order of the government, we have allowed private respondent number 5 and 6 to operate the said two ghats. Now they cannot do this.
How is it possible 5 and 6 if it is a private hut? Where is your statement that it is a private hut?
My lord, may I kindly say, page 7, para 6. The petitioner requested that it is a matter of regret and resentment that during the panchayat year 2025-26, the petitioners have been not allowed to call NIT by the authorities, which is done every year by the petitioner in respect of the ghat markets within their jurisdiction. But the two markets, namely Salabila Bhandara Parghat and number 5 Basbari Bagan Parghat, have been directly handed over to two private persons.
Yes.
By the 6
Yes.
and 7.
Panchayat, how are you doing this?
Lordship, may I submit before that
Yes,
one thing, my
please.
lord?
IWP,
Page 18, my lord, IWP,
1-8.
1-8.
Ah.
They have type copy, they have annex in annex of 5. This is a letter from the executive engineer IWT to the executive engineer, to the chief executive engineer, Jilla Parishad, my lord, Marin, my lord. Reference, Lordship, may kindly have a look. Government notification number, so and so dated 5/7/2025. This notification is not under challenge. Under this notification, this Parghat was handed over to the IWT because the government has declared that private ferryghat to a public one. As per the Northern India Ferries Act, my lord, section 4.
So it is no longer private.
Yes, no longer private. That's why they have handed over these two ferryghat to the IWT.
Is there any notification to the effect?
This refer 5/7/2025.
Where is that?
They have not challenged the notification.
Understood, but let me have a look at it also.
In
Please.
5 minutes, I will get the notification.
Huh?
First, may give me 5 minutes. I will get the notification.
We'll have after some
My
time.
lord,
Yes.
that may be.
No,
but
no,
my lord, rule cannot, this notification, this order 5/7/25, which my learned friend has referred, this cannot take away the provisions of rules.
Act.
Rules also cannot be taken because this is the only executive instruction. The executive instruction cannot overtake the rules frame. So the rules have something better in position than this executive order. This is rule is subordinate legislation, and this is not subordinate legislation. This is only a person's letter, and rules are made by Lordship is aware about that. After
No,
consulting
I'm
with
not concerned with this. You see, the question is what she says, that in view of the Northern Indian Ferries Act, 1968.
Section 4, 1978.
But that should be published in your gazette also.
No, it's okay. No, that act
him-
is already published.
Yes, act. This is act.
Act
Not
is published. The question is, they say that this particular huts, which was the question, is now made up public, not a
Public.
private.
Yes.
So if it is a public, then it has to be done by the whoever the authorities, the state, the person doesn't have. So let's have a look
Yes.
as to whether in that notification, this particular hut is mentioned there.
Yes.
that 5/7/25
Which
notification,
is
I will
the-
get this.
Which is the effective date? That is also. From which date it has been affected, that lordship would
Yes,
kindly examine. that.
definitely.
Obliged. After
Also,
some
after
time.
some time, my lord.
After some time.
Lordship.
And after 12,
Lordship. Yes, my lord.
May I please have a look?
what is this?
The non-payments of contractual bill, my lord.
On payment, how much?
It's 3 crore 9 lakhs. Some,
You're asking from whom?
Water Resource Department.
Does it have any relation with the government, state, central government?
No.
You sure?
Sure.
Issue notice, you are water resource, issue notice returnable by 15th of December 2025. Ms. So-and-so accepts notice on behalf of the respondent numbers 1, 2, and 3. The case of the petitioner herein is that the petitioner, who is a class 1 contractor under the Water Resource Department of the Government of Assam, had undertaken various works and that to the satisfaction of the said respondent authorities. There's an amount of rupees. It has been pending since when?
Since 2020, madam. 22, 20, the work order. By 21, it was over.
One is 2012.
12.
When? When was it completed?
12. 90 days is the period. 90 days is the period, madam.
Then why should we issue notice in this 2012 business? Only for this 2020 is otherwise. When did you complete?
It was completed, madam, within the stipulated time.
How do you know? Where is the completion certificate?
Completion certificates, lordship, I have annexed the liability certificates, my lord.
Where?
Liability certificates were issued on
No date.
18/6/25.
Huh?
18/6/25. Page 25. ma'am.
Submits that he has carried out various works to the satisfaction of the respondent authority. And on 18/6/2025, the executive engineer, Kamroop Rural Water Resource Division, have given a liability certificate to the tune. A liability certificate to the effect that an amount of rupees 2,86,99,889 is payable to the petitioner for 2 works of the year 2020 and rupees 22,40469 for a work pertaining to the year 2012. The petitioner thereupon have sought for continue representing the respondent authorities by submitting representation. However, the said amount having not been paid, the petitioner has approached this court. The respondents are directed to bring on record their stand by filing the affidavit. This court observes that the maintainability of the petition on the ground of delay and laches is kept open in respect to the claim of the petitioner pertaining to an amount of rupees 22,40469, taking it as prima facie, it appears to be a belated claim.
Obliged.
Nine.
May I please, Lord? Well, in this case, my lord, the petitioners, my lord, are my lord, fish and poultry traders lordship. By a common order, my lord, 54 cattle, my lord, fish and poultry traders lordship, page 23 lordship. My lord, kindly see, among 54, my lord, petitioners are 4. My lord, they were, my lord, their licenses were cancelled, my lord, without issuing any notice, without hearing nothing, lordship, the petitioners lordship.
What were you doing? You have licenses.
Yes, Lordship.
Now what
My
has
lord,
happened?
licenses, Lordship, I've stated, Lordship, in paragraph four, particulars is given, Lordship, in paragraph two, Lordship. Paragraph two, particulars is given, Lordship. Subsequently, the plots were allotted plots were also cancelled, Lordship, without any notice, without hearing, Lordship.
But tell me how you can do business there?
My lord, as per the Mekir, this is the my lord, rules, Lordship, regulation. Okay, Diana, quote. This is my lord Mekir Hills regulations.
Regulation.
My lord, this is regulation 1953. My lord, subsequently it was renamed as my lord Karbi Anglong district trading by non-tribals, Lordship, regulation 1953, Lordship.
First, look at page 39.
As per Lordship, section 7, Lordship.
Page 39 of the book, my lord.
Yes, what is it?
My lord, this is the regulation, my lord, framed by under paragraph 10 of the 6th schedule to the Constitution of India, my lord. And the paragraph 10 of the 6th schedule of the Constitution empowers the autonomous council to make law, my lord, regarding the trading by the non-tribal. So that is the law, my lord. That is
No person other than a tribal resident in the district shall carry on wholesale or retail business in any commodity in this district except under and in accordance with the terms of the license issued in their behalf by the district council under the provisions of this regulation.
And the license is issued for a period of 1 year and it is required to be renewed, my lord, by paying the fees, my lord. And the petitioner has not annexed, my lord, Lordship will look into Annexure 1, page 20. That is the license issued in the year 2007.
Well, I have stated in paragraph 2, Lordship.
And no other license has been issued, my lord. Annexure 1, page 20, my lord, date 1/9/2007. And the first column is, my lord, clause number 2. The license is valid for a period of 1 year.
And may be renewed from time to time for a similar period on payment of prescribed condition.
Condition, my lord. And it has not annexed that they have paid the renewal fees. They have paid the, my lord, license is renewed, my lord.
And what is this? Search by year some case? What is annexure 2?
Annexure 2, Lordship. My lord, background is that Lordship. Two individuals had quarrel, Lordship, in the market, Lordship. On 14/3/2025, quarrel was there, Lordship. On 15/3/2025, my lord, on that grounds, my lord, randomly all the license were cancelled, Lordship. My lord, against that person.
But tell me, do you have a valid license? Yes.
My lord, there is provision, Lordship. We are expected that the by paying late fee and fines, Lordship, we will get the license renewed.
But you don't have a license.
My lord, now, my lord, there is provision, my lord, rule 7, Lordship. There is provision, rule 7, Lordship.
If any person contravenes any of the provision, he shall be liable to a fine which may extend to 1,000 rupees. Okay, pay fine. If that is the reason.
Yes.
Lordship, we are looking to page 42. That has been amended, my lord. Page 42 is there in the book. Page 42, 7. If any person contravenes any of the provisions of this regulation, he shall be liable to a fine which may extend to 200 rupees, but such fine shall not be less than 50 rupees, and in default, simple imprisonment for a term not exceeding 1 month. Provided that trading without client's license may be compounded by the Secretary of the District Council or any officer duly authorized by him on relation of the composition of fees not exceeding rupees 100.
So they have reduced.
My lord, that is reduced. Then, Lordship, we have framed the rules, my lord. Lordship may look into page 47, page 58, my lord.
Rules.
This is again 56.
58, my lord.
Page?
Page 58 of the book. We have framed the rules, my lord.
These rules may be called the Mercurial District raising by non-tribal rules 1976.
Okay.
So my lord,
Rule 7.
Rule 7, terms of license renewal and issue of duplicate license, that is there, my lord. Then the provision of 10, my lord.
And appeal against the refusal to grant license by as well. That's a different thing. I'm not on that.
7B, all license shall be renewed on or before 31st December of the year for which they were issued. Well, Rule 7B,
Understood. Everything is understood. But the fact remains, whatever may be,
my lord.
a license, if it is renewed, means a license which have been issued can be renewed.
Can be renewed.
They are willing to pay the penalty.
My lord. Lordship will look into
We are ready.
Rule 8, my lord. Rule 8.
We are ready to pay, Lordship.
That is what I'm
Rule 8, my lord. On receipt of application under Rule 3, they have to submit an application, my lord. The secretary shall cause an inquiry.
Collector passed the decision, and after having satisfied that the applicant is not in a manner desirable to use the license, trade may issue a license under Rule 5.
So the inquiry, they have to submit the application. The secretary will make an inquiry, and thereafter, my lord.
Okay? No, that is not for renewal. That is for application.
Section 3, as per Rule 3, Lordship.
That is for only for application.
My lord.
Yeah.
As they are, my lord, a license has already elapsed, my lord. So they have to submit the application, my lord. The term of the license has already been elapsed, my lord. So they have to submit the application for renewal, my lord. Then my lord, it is required to cause an inquiry the bona fide of this, my lord. And there is an allegation, my lord, that they have sublet it, my lord. They cannot sublet it, my lord.
No, Lord.
Are these people subletting?
Sublet it, my lord. There is an allegation. They have denied it, but in the allegation there is their notice in the there. But in this case, they have not annexed it. In some other cases, they have filed that have not been listed. That is in the another case, but notices were issued to them, my lord. They have not annexed in this particular writ petition. Another writ petition was filed that has not been listed. In that writ petition, my lord, they have annexed the notice issued to them, my lord. And the notices were issued to all the persons, my lord. And they have, my lord, there is a clause that they have, my lord, sublet it, my lord. These conditions are there. So at this case, Lordship may issue notice, my lord. I take instruction in this particular case, my lord. In other cases, my lord, they have annexed the documents that notices were issued to them, my lord.
But in this case, no notice has not been issued, Lordship. Nobody was
Lord,
served
we
with
look
taking
into
the-
another.
No. It is not the question of issuance of a notice or no notice. Thing is, it has not been extended beyond the period of time. You have also not paid the license fee, renewal. It is also not in doubt.
But it can be renewed, Lordship.
Understood. So now the question is how we get it renewed. That is the issue.
Lordship.
So obviously, I can't pass on an interim order for renewal. You have to issue a notice to him, giving him, and on the next day, you can dispose it of, thereby granting you the permission to apply and get a renewal. This is how can be done. Don't you think so? Tell me any good reason, any other better way.
Means of livelihood is there. That
Sitting
is
in
why-
my sitting in my shoes or standing in my shoes. Tell me. Give me any other way out. Is it possible? You're a seasoned lawyer. Tell me.
Hello, we
Have to
submitted
issue a notice.
representation, Lordship. We submitted representation, Lordship. Actually, this is a representation last page, Lordship. Nobody was, in the copy, nobody's sign is there. On behalf of it was submitted, Lordship. Hello, individually will approach, Lordship, to pay, fines, whatever, my lord, fees is required, will pay,
That
Lordship.
I'm going to give you. That permission I'm going to give you.
Yes, Lordship.
In my order that in the meantime you can very well approach for renewal
Lordship.
and they may consider
Lordship.
pending notice.
Lordship.
I think that is a fair way by which you all people think can be taken. But I can't set aside the order as a whole.
Lord, what I am submitting, my lord, their families are, my lord, depending upon their income, Lordship, earning, Lordship. My lord, their business may be directed to be allowed to be continued, Lordship. Subject to
So you want that this court should, no, you'll be permitted. If they in the meantime consider your application, you may be permitted. That is a different thing. But without the permission being granted by or renewal being granted, this court cannot pass an order because that will go in violation of the.
Yes, your lordship, as your lordship thinks it, my lord.
Okay, let me write. Let's see how it works. Issue notice. Mr. Sutia, we would like to finish it off by 15th of October.
Not from 15, but the 16th.
Okay, 17th of October.
My lord,
We would like to finish it off. You have to file your affidavit by 15th.
my lord, my lord.
Issue notice returnable on 17th of October 2025. Have you seen B. Chaudhary anywhere? This Assam Marketing and Agriculture Department is who is the standing counsel? Who can appear? Okay. None appears on behalf of the state government where the matter is called.
State
Mr.
government.
Jesuti accepts
State
notice
government.
on behalf of the respondent number 2, 3, 4,
5,
5,
7 and 8.
7, and 8.
District Commissioner.
My lord, and for the.
Good stuff. On behalf of the respondent number 1 and 7,
6.
6, the counsel for the petitioner is directed to serve extra copies upon Mr. D. Nath, the learned senior government advocate, who would be in a position to accept notice. Extra copies upon the respondent, upon Mr. Jesutia be served pertaining to respondent number 2, 3, 4, 5, 7, and 8 during the course of the day. The petitioners herein are agreed by the order dated 27/5/2025, isn't it?
Two orders, lordship.
27/5/2025 and 12/8/2025. Whereby the license of the petitioners have been cancelled. With immediate effect. And further directions have been issued to the executive officer of the Difu Municipal Board to revoke the market space allotment so issued in favor of the petitioners. The learned counsel appearing on behalf of the petitioner submits that the said action which have been taken by the respondents by the authorities under the Karbi Anglong Autonomous Council is in complete violation to the principles of natural justice, inasmuch as no opportunity whatsoever have been provided prior to cancellation of the licenses in question. For contra, Mr. J. Chutia, the learned counsel appearing on behalf of the Karbi Anglong Autonomous Council as well as the officials submitted that in terms with the provisions of the Mickey Hills District bracket trading by non-tribals bracket close regulations 1953, as well as the Mickey Hills District bracket trading by non-tribal bracket close rules 1975. Where a non-tribal cannot be permitted to carry on wholesale or retail business in any commodity in the district, except under and in accordance with the terms of the license issued in that behalf by the district council under the provisions of the regulations of 1953. The learned counsel further submits that though these petitioners, though the petitioners had licenses, but these licenses were only valid for 1 year, and there was no subsequent renewal, as would be very much apparent from the materials, from the documents, as well as the from the documents enclosed to the writ petition, as well as the pleadings made in the writ petition. The learned counsel, standing counsel, further submitted that though a renewal can be permitted, but that is subject to taking into account the character, past antecedents and bona fides of the applicant, and also payment of the requisite fees and penalty for the period when no renewal was sought for.
Paragraph, my lord, page, if lordship look into page 62, clause 8, my lord. If any contravenes any provisions of the license, it can be cancelled. Page 62, 8, rule 8, if the license contravenes any of the provisions of the regulation or any other conditions of this license, or is found to have been made any incorrect statement in his application for a license, or in compliant condition of 7 of this.
He has, Mr. Sutti, he has yet to file. Original application is okay.
Madam.
The second application is yet to file.
Yes, madam.
So
Then
that,
we will consider
those
it.
will not come in.
Yes, madam. Then we will consider all those things, madam.
Mr. M.H. Ahmed, the learned counsel who appears on behalf of the petitioner, however, submitted that with the cancellation of the licenses, the petitioner's right to livelihood has been taken away, which is a facet of Article 21 of the Constitution. And the same cannot be taken away in the manner in which it has been sought to be done. So, this court have given a thoughtful consideration in respect to as to whether the petitioner is entitled to any relief, interim directions, interim measures pending the notice. This court finds it relevant to take note of that the provisions made under the regulations of 1953 as well as the rules of 1977, rules of 75, whereby certain restrictions have been imposed, the same has been done so in terms with the provisions of the sixth schedule to the Constitution of India. The provisions of the said regulation, or neither the regulation nor the rules have been put to challenge. Further to that, if the petitioners have licenses to carry out the business, the petitioners must also be aware that the said licenses are required to be renewed, as it is the very stipulation in the license itself that it is valid for a period of 1 year. Nothing has been also brought on record that the said licenses have been issued, have been renewed. Considering the above, this court in the interim would not be in a position to pass an order without taking into account the stand of the respondent authorities to the effect that the petitioner licenses ought to be renewed. The licenses be directed to be renewed. Be that as it may, this court also finds it pertinent to take note of that the perusal of the rules, regulations, as well as the rules, regulations of 1953, as well as the rules of 1975, provides a procedure for renewal of the licenses subject to certain verifications as well as payment of the renewal fees and penalty. The learned counsel appearing on behalf of the petitioner also submits. Petitioner also submits that the petitioner may be permitted to file appropriate applications before the concerned authorities seeking renewal of the licenses, and the petitioners are agreeable in the meantime to pay the requisite renewal fees as well as the penalty as prescribed in the regulation as well as the rules. It is the opinion of this court that, taking into account that there is no interim directions passed, the petitioners ought to be granted such liberty. Accordingly, next, this court observes that pending notice, the petitioners would be at liberty to submit applications before the concerned authority seeking renewal of their licenses, and the authorities shall duly consider the said application within the ambit of the rules, regulations of 1953 as well as the rules of 1975. And further, keeping in mind the provisions of Article 19(1)(g) of the Constitution, 19(1)(g) and Article 21 of the Constitution, which are fundamental rights enshrined in the Constitution of India.
Well, GSM may be shown in the cause list. GSM may be shown in the cause list.
No. None has appeared. None has appeared for GSM as such. Copy be served upon student.
Copy not served, no.
Copy be
GSM not
served
in the
upon.
cause list.
You have not served copy upon.
Not served. Not served, my lord. We have checked the record, my lord.
The party is here, my lord, without copy, my lord, I don't know how. it
Lordship will
is.
see the record. We have checked, my lord. Lordship will see.
I'll provide my copy, lordship.
Not shown in the cause list even, my lord.
I'll provide.
Why haven't you served copy?
No.
My lord, it was given for serving, my lord.
My lord, Lordship will see, my lord.
My lord, it was given for serving.
Okay, we
at the
strike out.
Filing.
Strike out the petition respondent number 1 and respondent number 6.
Lordship.
Then you know the consequences. Without the DC being there, how can you get any relief? You know it. It's the counsel who is doing it. The counsel the counsel for the petitioner had submitted at the outset that the names of the respondent number 1 and 6 be struck off, taking into account that the dispute involved in the instant proceedings are primarily related with the Karbi Anglong Autonomous Council. Accordingly, the name of the respondent number 1 and 6 are struck off at the risk of the petitioners. The learned counsel appearing in behalf of the petitioner is directed to file a fresh memo of parties in this regard before the registry of this court, and the registry shall, on the basis thereof, make necessary correction in the cause title and update in the CIS.
One thing, lordship, may I pay, lordship. So far, my lord, the cancellation of allotment of plot, lordship, that plot may not be given to other person, lordship. Otherwise, they will be business.
That we'll see. As of now, you don't have a license.
My lord, now, that was land.
Do you have a license?
My lord, plot where.
Plot, forget about that. Plot will come when you have a license. You don't have a license.
My lord, if license is renewed, that is allowed lordship.
Then very good. We'll see.
Then my lord, plots will have there. will
Are
be
you
some-
there in the plot or not?
Not now, my lord.
Now,
They have to, my lord, submit the renewal application within a stipulated period. Lordship may grant them time to file the application for renewal within a stipulated period.
If they don't file it, that is
My
their
lord,
lookout.
my lord.
now
Why should
plots,
I-
my lord, if it is
My lord.
given to some others, lordship, there will be some.
So what?
Situation.
You don't have a license. You don't have the state government to help you out.
Okay. So, size.
Mr. Mahmood, without a challenge to this notification, it is difficult for you.
Give any copy.
You need to challenge this.
When there is some diversion in the section of the act, my lord, then perhaps
It is
should
no
publish
longer a
in-
private hut. Private hut. It has become a public hut. Public, what you call, they say it to be public.
But all along, my lord, since last years, we had
It has
called
become a
an,
public ferry.
we have called NIT, kindly see that I have given a copy.
Mr.
Certainly,
Mr.
they may do it, but
Everything is understood. But this must have this happened in 2025 July.
Yeah.
So unless you challenge this, you cannot. There's no point.
the gazette revision is not necessary, my lord.
This is requires the gazette notification. It is being directed. No? The director here is requested to publish the notification in the next issue of
That
the
is there. But whether it is published or from whose date it is effective, that is a must, my lord.
No, it will be effective from that day.
No, from the day
Hmm.
when it will come into force, it will be reflected in the gazette notification itself that this is published in extraordinary Assam Gazette so and so, and it will be effective.
Okay.
Let the gazette, my lord, that is very important.
Let us have it on Monday as to whether
Yes,
there was
yes.
a gazette.
That will do, man. That will do.
The
Because
petitioner
similarly,
hearing,
Muslim Marriage Act, that was act was made by the government, but that was not published in the gazette notification. So it was given not effect by coordinated bench of this Honorable High Court.
Miss MD Bora, the learned standing counsel of the IWT, drawing reference to Annexure 5 of the writ petition submits that the petitioner is not entitled to any relief, taking into account that the hut in question have been brought within the ambit of public ferry by the notification dated 5/7/2025, the reference of which can be seen in the very communication dated 15/7/2025, which is annexure 5 to the writ petition. Mr. M.U. Mahmood submits that in terms with where is it required that it is mentioned that it is to be in official gazette published?
It is not mentioned in the section 4, my lord.
Then,
Yes, it is there.
uh, no, it is there. Finally come to 4F. Submits to make that in order to make a declaration in terms with section 4,
Yes, 4F.
the said declaration has to be made by way of official gazette. Has to be made and published in the official gazette. List this matter on 24/9/2025. In the meantime, Ms. M. Deborah, the learned standing counsel of the IWP, is directed to apprise this court as to whether the notification dated 5/7/2025 have been published in the Assam Gazette.
Obliged.
4F, my lord, proceed with the act, my lord. 4F, please discontinue any public query regarding publishing in the official gazette, my lord. Discontinue any public query. This is not discontinuation of any public query, it is a transfer by private query to a public query.
No, that must be published in Gazette notification. Similarly, the Act, my lord, Assam Panchayat
Just
Act was,
assisting, my lord.
was
This line, discontinue any public query.
Anyways, it has been
Lord,
already.
provision of law cannot be bypassed by oral argument.
Well, here I am recorded it as his submission.
Lord, Act 2, my lord. Act
On
2,
Monday,
24th.
24.
24.
I can tell.
Okay.
Sir, I have handed over the act.
What is this?
But this is pertaining to non-payment of contractual bills, my lord. The work was required with regard to supply of water pump sets, my lord. The
Supply
total,
of?
total bill amount was 18,97,000. When part payments have been made. So now, my lords, an amount of 1,78,000 is pending. That has not been paid, my lords. Because in fact, the government had in 2023 had directed the chief engineer to examine and make payment. Despite thereof, no payments have been made.
Issue notice making it returnable on 8th of December 2025. Mr. N. Upaite accept notice on behalf of the respondent number 1-4. Extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was issued a work order for supply of 13 numbers of public sets for construction of Baharghat and Mahatoli Irrigation Scheme AIPT for the year 2009-10, and the items were delivered to the authorities on 7/6/2012, 11/6/2012, and 18/6/2012. Having completed the supply, the petitioner requested by the communication dated 27/6/2012 for payment of the amount of rupees 18,97,896. The respondent released in total on various dates up till 29/3/2021. The total amount leaving behind 1,78,976. The petitioner submitted a representation for the payment of the remaining amount, and the same having not been paid, the petitioner has approached this court. The respondents are directed to file the affidavit on or before the next date, providing you information as to whether the petitioner is entitled to the remaining amount of rupees 1,78,976, and if so, when the said amount will be paid.
Item
11.
13 is
Yes.
Well, this is regarding settlement of ghat by the Gaon Panchayat. The NIT was called and three bids were found valid. Out of that, two bidders quoted the same price value at 99,000.
Who? You and the private
Respondent
respondent.
number 7,
How much both of you quoted?
99,000.
And it has been given to him
It has been given to him.
without any reasons.
Without, my lord, it was to be settled at the Gaon Panchayat level, my lord. It has been settled by the Anshalik Panchayat, my lord, and no lottery was conducted. I was in the dark, Gaon Panchayat was in the dark, and my lord, the ghat has been settled with respondent number 7,
Where is it?
my lord.
Where is the tender condition which says that if it equals, then you have to go for that?
My lord, well, tender is at page 22, my lord.
That I know. Where is the condition? When
Condition,
both
my
are
lord,
equal?
yes, item number was 7, my lord. Go. Item number 7, item number 14, my lord. 14A. At page
More than
55,
one bidder submits the
20.
same tender value for any ghat bazaar, and if they are otherwise found eligible as per here, then the settlement shall be made by holding a lottery amongst those local bidders. Among multiple bidders who select one bidder shall be conducted in a transparent and fair manner in the office premises of the concerned panchayat by the standing committee of Gaon Panchayat so and so, or by specifically constituted selective committee for the bazaar in so and so. Procedure of the Iman shall be prepared with the mandatory signatures of the concerned and participating. And you did not sign there. Yes.
I'm for respondent 7, my lord. Now, the petitioner, my lord, he did not submit the police verification. The instruction which has been provided to me, my lord. As clause 19 says that at the submission of bid, there has to be a background check. Page 27.
Where?
Clause 19, page 27. At the time of submission of the bid, it is mandatory for every bidder to submit background verification
This
certificate.
is as per some executive order.
There's an executive order which I found, my lord.
That executive order is, I think, clause 4 and 5, na?
Clause 5, 6.
5 and 6.
Yes.
4 and 5. 4 and 5. 5 and 6, no, 4 and 5, yes. No settlement of huts will be awarded to a lessee who is involved in it so and so. Each lessee shall furnish a police verification report from the local police stating his antecedents while submitting the bids for settlement of huts, house, so and so.
So we have already started and we have already deposited the entire amount.
I have started, we can state there is no quarrel with that. No problem with that. Unless this is being done. And Panchayat, madam, no copy has been served.
That's a copy, sir. But
Then tell me what is the reason why you have done this?
that's in this test notice, Nego.
Okay, before vacation. Before vacation, I'll consider whether a stay is
Let's-
required or.
That's
Because he says that he did not have a police verification.
that's it.
On the other hand, petitioner says that he complies with everything, and in terms with clause 14, the mandate has not been followed. On this issue, you take the instruction and be.
Right.
Issue notice making it returnable on 25/9/2025.
Can it be on 24th or 26th?
Okay, we stayed. No, we stayed.
No,
No,
let it
let us stay
let-
till we can have it after vacation.
25th.
Then on 25/9/2025.
That's it, that's it, 24,
Huh?
not 25, 24,
What? 20?
24,
Why?
because 25 I'm not available. That's,
Before. Very good. You can produce that there. We can have it on Monday also. Obtain that instruction Monday. You'll be more free than on 25th. Then you'll be have a more relaxed period for another 3 days.
no, that's it, 24. Right.
Issue notice making it returnable on 24/9/2025. Ms. Enbora accepts notice on behalf of respondent numbers 1, 2,
4 and 6.
4, and
And 6.
6. Mr. Escount accepts notice on behalf of the respondent number 7, who is also on caveat. For the you can accept for the secretary, na? No.
That's why I'm accepting. So I'm
For the-
making 6.
For the time being, this court is not inclined to issue notice upon the respondent number P and respondent number
5.
5. Extra copies of the writ petition be served upon them during the course of the day. The case of the petitioner herein is that a notice inviting tender was issued on 3/6/2025 for running for the purpose of settling the Bir Singh Gaon Panchayat, which one? Ghat?
Bir Singh Jogomaya Ghat.
Bir Singh Jogamaya Ghat. And various other bazaars and ghats falling within the Bir Singh Gaon Panchayat. The present dispute pertains to the settlement given in favor of the respondent number 7 by the impugned order dated
20 August.
page 28, impugned order dated 28/2025 of the Bir Singh Jogamaya Ghat in favor of the respondent number 7. The learned counsel appearing on behalf of the petitioner submits that clause 14 of the terms and conditions of the tender categorically mandate a procedure to be followed when the bidders who submit the bid have quoted the same tender value. And when the bidders are found eligible. The learned counsel appearing on behalf of the petitioner submits that the petitioner had quoted rupees 99, petitioner had quoted rupees 99,000 as well as the respondent number 7. But without following the procedure laid down in clause 14 of the terms and conditions of the tender, the same have been settled in favor of the respondent number 7, and as such, the said action calls for interference. The learned counsel for the petitioner further submitted that this is a fit case wherein the impugned order dated 28/2025, whereby the settlement has been given in favor of the respondent number 7, is required to be stayed. Per contra, Mr. S. Count, appearing on behalf of the respondent number 7, submitted that clause 14 of the notice of the tender documents of the tender conditions would only apply when the same tender value is quoted by two eligible bidders. The petitioner herein was not eligible, taking into account that the petitioner did not comply with clause 19 of the tender document, as well as the executive order issued by the Secretary, Additional Chief Secretary to the Government of Assam, Panchayat and Rural Development Department, which mandates at clause number 5 the requirement of furnishing the police verification report. He therefore submitted that the question of granting an interim at this stage does not arise. This court inquired with Ms. Enbora, the learned standing counsel of the Panchayat and Rural Development, as to whether there has been compliance by the petitioner to clause 19 of the tender document, and further as to whether, and if so, whether the mandate of clause 14 of the tender document have been followed. The learned counsel submits that she would obtain instructions in that regard. Taking into account the above, this court is not inclined to pass an interim order at this stage and would consider on the next stage so fixed. The Standing Counsel for the Panchayat and Rural Development Department shall obtain instructions in respect to the above query and place it without fail before the court. Caveat stands the charge. First, second, how many times?
My
You have filed the writ petition.
My lord, first time.
Okay, dispose.
No reference.
Ravi brothers, same types.
Same parties.
Yeah, I got order to be distributed. Given how much amount?
2,35,384 remains.
Silo liquidity. Huh? I got the Arveta Ravi brothers order.
Obliged.
Same date. Huh?
Lordship.
But Mr. Upadhyay, kindly take note of one very dangerous thing which he have mentioned in the petition. He's an MSME.
Lordship, yes. I've seen you.
Yes, what is this? This one.
Lordship.
Where is Mr. Pinack? Isn't that the order passport?
It's 50, my lord.
15 line is long over.
Okay.
Then
So-
what remains?
Uh,
The last
50
date for submission of the last date for issuance of the work order is on 15/9.
But that, my lord, in some district, my lord, the tender has not been issued, my lord. We are from Nalbari, my lord.
So what? They cannot say so.
At this stage, my lord, we may be allowed to register ourselves, my lord.
Hmm?
In the Seva Setu, my lord, we are not allowed to register ourselves in the government.
You cannot now be allowed. You are there.
Lordship, P. Nayak is there, but he is on Lakes on court number 7.
Okay. Hey, is it to select? Hey, hidden at order back recently. No, not that one. Rookie order. Visual. You are challenging the clause H? No.
Lordship, clause H, C.
You are not challenging clause H. You are challenging clause H? No. To allow the petitioner to register in the Shiksha Setu portal to enable the petitioners to participate in the quotation. How is it possible? And you have not challenged the clause also. Huh? All copy-paste petitions. This is another copy-paste petition. Mr. B. Chetri, he made the first petition with a mistake, saying that there is a commissioner and secretary of the elementary education department. I said that it is not possible. Then it was found out that it should have been the director of elementary education department, or you should have made the commissioner and secretary education department. You don't do that. And this is being repeated. And Mr. B. Chetri is responsible for spreading that petition everywhere and coming up with the same defective petition all. Day before yesterday, Mr. B. Purkasta came over. Hey, Situ Solari.
Commissioner.
Isn't this Mr. Naik?
Yes, no. At some point of time, Lordship will. Commissioner.
I fixed the similar matters on there on 20.
20. When day before yesterday, I think.
That is another one. I fixed one matter. That day, one matter I passed an order. That is of Mr. B. Chetri. But I passed that order on
11, I think, Lordship.
11.
11.
11th, I passed that order. But you have come after 15-9. And now you want to register. Mr. B. Vibhas Pathak, your matter is also similar.
Regarding this blacklisting, debarment, yes. Item 56. One is 56, one is.
Isn't it, Mr. Naik? Same
matter, Lord. And day before yesterday, one matter came here, Lordship decided not to pass any interim.
Interim order, nothing.
So you-
No, here to all, those are two there. Day before yesterday matter is also condonable to the extent that it was filed on 15-9.
Yes.
Here they have moved on 16-9. I think the information travels slowly.
My case is that I did not get any notice at all. Till now, I have not got any notice or any information, but then I am not being able to, my lord, register in the Setu portal.
Understood, Shiksha Setu, you have not been able, but the bus has already traveled.
No, if
now
moment I am debarred, I am not concerned about this particular tender. Moment I am debarred, I cannot
No, it
participate
has-
for another 1 year.
It has been submitted by the additional advocate. We'll consider,
My lord.
but not here. Not in respect to this. So the only thing both of you have now is for registration in the Shiksha Setu. But you give up your life as regards participation in the present. Because this has already passed.
No, that I have not prayed. I have not
Both
prayed
of
for
you.
that. I have not prayed for that.
We'll consider as to whether there can be a debarment from enlisting, because in that earlier order I said that you cannot debar.
Yeah.
Because once you apply, you cannot debar. That is my finding in that Mr. B. Chetri's order. There I have given it. But you having been debarred, now the period is already over.
But in this one, Lordship, this is MN Enterprise, Lordship. The prayer is there, interim prayer for staying the quotation as well as tendering process.
The tendering process, you reject it rightly. Let them go to the division bench. Division bench judges are more kinder than me. Issue notice. Making it. When did I fix that other matter? You just find out. Yes, sir.
20 to 10, my lord. 20 to 10.
Should notice making it returnable on 22/10/2025. দুইটাতে লিখবে দে এমন রেট দুইটাতে এটাত হল আর
আলী।
আৰু এইটো মিস্টার বি বাট মিস্টার P Naik, the learned additional advocate general accepts notice on behalf of the respondent numbers 1 and 2. While again further sharing the soft copy, also inform your colleagues that kindly make the commissioner and secretary Department of School Education as a party. Okay, as respondent number 1. Because he cannot be elementary education. The petitioners herein Mr. Pathak, your case is only one petition.
Two petitioner.
The petitioners herein, extra copies during the court. The petitioners herein have approached this court, challenging the actions of the respondent authorities in not registering the petitioner, not permitting the petitioner to register in the Shiksha Setu, which is the portal wherein the petitioners are required to register in order to participate in the tendering process for supply of school uniforms pertaining to the year 2025-26. The admitted facts of the present case is that the petitioner had supplied school uniforms earlier for the academic year for the year 2024-25. And while supplying some of the uniforms were not as per the specifications as set out in the guidelines of the year 2024-25. However, it is the case of the petitioner that immediately on coming to learn, the petitioners have rectified their mistakes and supplied school uniforms to the concerned school authorities and to their satisfaction. Be it as it may, on the ground that the petitioner had supplied certain faulty school uniforms, they have been put in a vendor's list wherein on the basis of which the petitioners have not been permitted to participate, to register in the Shiksha Setu. The grievance of the petitioner, therefore, is that that in terms of clause H, of the guidelines issued on 8/8/2025. Without registering in the Shiksha Setu, the petitioner cannot participate. And the act on the part of the respondent authorities not to consider that they have duly rectified their mistakes by supplying the school uniforms as per specification, and thereupon also putting the petitioners in the vendors list have violated the petitioner's rights under Article 19(1)(g) of the Constitution. Per contra, Mr. Pinayak, the Learned Counsel Additional Advocate General, had submitted another order. Taking into account the above, Mr. Naik, your submission that they recorded same lordship. Per contra, taking into account the above, and further, taking into account the above submissions, and further, clause H 1E, na?
One C, my lord, for registration, D and E, my lord.
Clause 1,
Case 43.
1E, 1E. That the, no, 1E, 1E. It has been mentioned that all work orders have to be issued on or before 15th of September 2025. As the last date of supply of the school uniforms is on 31/12/2025. And the writ petitions having been filed in only on 16/9/2025, after the period, after the last date for issuance of the work order in question. This court is of the opinion that the question of passing any interim order at this stage does not arise. The only question therefore arises is as to whether the respondent authorities in future can stop the petitioner from participating in similar tenders. The respondents are directed to bring on record their stand by filing their affidavits on or before 15th of October 2025. Liberty given to the petitioner to file their reply, if so any, by the next day. An attempt shall be made to dispose of the writ petition at the earliest.
In the meantime, my lord, you may be permitted to register ourselves, my lord.
What?
In the state, my lord.
No. Nothing remains. Period is over. You come very late. I allowed that one only because he came on 11/6, 11/9.
Our cases would be for future tenders.
Future, I'm taking care of it, whether it can be done. Because you see, Mr. Chetri is on. Then I have made certain observations. It may help. When is that? That is also on 22.
That's on 22nd.
Same day.
22nd.
Mr. B. Chetri's case also.
22nd.
It is motion. Oh, yes. What is this so big a matter?
In fact, I'll have to withdraw this. There is a formal defect in the petition, my lord.
Huh?
There's a formal defect in the petition, my lord. It's caught attention, my lord.
What is the formal defect?
My lord, your lordship will find page 9, paragraph 8, my lord. For the entire chart, the grounds, my lord, which are
paragraph 8.
paragraph 8. Inadvertently, my lord, the
It was
draft.
rejected in the technical format and marks not awarded in the petitioner despite the following. But nothing is there.
Yes, there was a chart, my lord, where I have compared it, my lord, how these marks ought to have been. I'll have to rectify
So why
that.
didn't you file an additional affidavit?
That, if your lordship permits, I can do.
Mr. B. Kaushik, the learned counsel appearing, this is only for environmental reasons, not
Yes.
for goodness
I
of
understand.
me.
I understand. In fact, I got an additional affidavit prepared also.
Mr. B. Kaushik, the learned counsel submits that inadvertently, the chart which was required to be inserted in paragraph number 8 of the writ petition was left out while preparing the writ petition. He therefore submits that he may be permitted to file an additional affidavit, thereby to include the chart in furtherance to what had been stated in paragraph number 8 of the writ petition, was take how much?
Can it be on Wednesday, my lord? We'll file it on Monday.
He submits that the additional affidavit will be filed by 22nd, and was taking into account the above, list this matter on Wednesday.
Grateful, my lord.
Date to deliver, huh? For motion.
16,
Yes, Mr. Chaudhary, what is this only child school?
My lord, this is that, my lord, gratuity matter, my lord. Gratuity, my lord, was paid by the school, my lord, in terms of the service rules which are adopted by the school, my lord. Thereafter, my lord, when, my lord, the centenary celebrations of the organization came, they, my lord, reviewed that, my lord, and raised the amount of gratuity. Thereafter, the petitioner, my lord, approached the controlling authority, saying that, my lord, after a lapse of 4 years, that gratuity had not been paid. And thereafter, my lord, there was a proceeding, my lord, and then, my lord, some amount of gratuity was increased, my lord, as per the calculations under the payment of gratuity.
So there is an order passed on the under what act?
7-4, payment of gratuity act, my lord.
7-4 order has been passed. Where is that order?
That your lordship finds at page, my lord. Look, would the lordship be kind enough to take up the next matter, my lord, item 17, my lord? It
Okay.
is same, my lord.
Both same.
Same, my lord. Two teachers, my lord, same school.
Page
That
70.
order, yes, my lord. Lordship finds that, my lord, at page 60, my lord, 60.
60. Same type, yes.
Yes, my lord.
This is by the assistant, we have the controlling authority under the Payment of
Payment of Gratuity
Gratuity
Act,
Act to an
my lord.
Montocolita Assistance Fund. So this order was passed on 4th of
This order was passed on, my lord.
4th of
This was 4th of March. 4th of March, 2025. My lord, there are two things that is to be adjudicated by your lordships now in this matter. My lord, the rules under the Payment of Gratuity Act, my lord, says that, my lord, if anybody is agreed
have
by
you
the,
filed an appeal?
my lord,
Appeal.
my lord, because ultimately I am on the perversity of the order covered by the willful case judgment, my lord. So, my lord, even if the provision of appeal is there, my lord, because I have come upon that, lordships may be pleased to consider, my lord.
Why I'm saying so, yesterday I had the occasion of taking up a map.
My lord,
It's was of the year 2016.
my lord,
Now the question arose as regards the Employees Provident Fund.
my lord,
This provision of 7-4 here
my lord.
is akin to section 7 capital A bracket 1 of the Employees Provident Fund Act 1992. Now, there is an adjudication being carried out thereupon. 2016, this court admits the appeal. The petition states everything going on for the last 1 year, 1 decade. Matter comes up before me yesterday. The counsel for the petitioner requests this court to kindly allow me to file an appeal now. And it becomes very difficult once you admit it, because now the moment is he falls upon certain facts, which being you are asking this court to exercise a tertiary jurisdiction. So certain findings of facts cannot be indicated by this.
I am not on fact at all, my lord, in this petition.
So if it will be only on a pure question of law.
Yes.
Because if it is on then obviously this court can disregard section 7.
No, section 7(7), my lord, is for the employer. If the employer is aggrieved, my lord, within a period of, my lord.
Any person aggrieved, no,
any
not employer. See,
by an
any
order.
person aggrieved by an order
Passed under 7(4).
7.
So 7(4) is an order which was passed, my lord, against, my lord, the school. So as it was passed against the school, my lord, so against that order of the authority, my lord, it is the employer had to go in 7(7), my lord. the employer, because the order was passed against the employer. So the employer had to go under 7(7) before the appellate authority, my lord. And the period was circumscribed there, my lord, 60 days, and
You are not the employer.
I am the employer.
So
I am the
therefore you
employer.
can go under 7(7).
I did not go before the 7(7) because by the time, my lord, because this is school, this is the Holy Child School here, my lord, in Guwahati, your lordship is aware, my lord. For whatever reason, my lord, there was a delay on either on, my lord, misadvice or wrong advice or whatever, my lord. So this period for going under 7(7) is there in the proviso. It is only for a period of 60
That I'll
days,
take care of it.
and thereafter 60 days,
No, Mr. Chaudhary, that I will take care of it.
my lord.
Taking into account that I'll say that this court is not entertaining in view of 7(7),
My lord.
and thereby give you the liberty of 30 days for filing.
But I am not on the facts.
Then later on you cannot. You
I am
cannot.
I am not in the facts at all, my lord.
Then let us
What?
come into the law.
My submission before your lordship is twofold, my lord. One submission is that, my lord, under the rule 10 of the payment of gratuity rules, my lord, a period has given that if somebody is aggrieved by the amount of gratuity which is given to him or not given to him, my lord, he may go to the controlling authority within a period of 90 days. And if he, my lord, goes beyond the period of 90 days, my lord, then, my lord, the controlling authority has got the power to condone the delay. So here in my case, my lord, the person, my lord, the private respondent, the teacher who retired, she went to the controlling authority after a period of 4 years. 4 years after retirement. Because at that point of time, my lord, in our service rules, which she accepted, my lord, the gratuity was capped at 1 lakh rupees. So we paid 1 lakh rupees then and there. When the, my lord, this school, my lord, they are, my lord, controlled by an authority called the Salesian Sisters, Don Bosco, whatever, my lord. Their centenary year was approaching. So in the year 2024, they amended their gratuity rules and upgraded the amount of gratuity to be capped at 6 lakh.
6 lakh.
6 lakh. So when after 4 years, this, my lord, teacher came to know that we have capped it at 6 lakh, then she went to the controlling authority, my lord, saying that I am not being paid as per the provisions of the Payment of Gratuity Act. Because the Payment of Gratuity Act has got a, my lord, its own calculation as to what will be the amount of gratuity.
And you did not file your reply.
I filed, my lord. I don't know what was done there, my lord, but it appears, yes, my lord. I have seen, my lord. It appears that, my lord.
Page 61.
My lord.
OP was given reasonable time to file WS. However, they failed to do so. Hence, the matter is decided ex parte.
I don't know, my lord. But the basic fact is that, my lord, regarding condonation of delay, my lord, one written statement they have perhaps allowed to file against that, my lord, application under Form N, which was filed. But for the condonation of delay, my lord, that was not considered. There was no separate application, and that condonation of delay was not considered. So that is one ground which I espoused before your lordship as to whether, my lord, a delay of 4 years could have been condoned like that, my lord, without giving me a notice. And also your lordship sees the other parties.
Issuance of notice, how does it matter?
Because then I would have, my lord, said that the ground on which the condonation was sought.
So you should have very well taken it as a ground in your written statement.
My lord, kindly see, my lord, that, my lord, he says, my lord, that because, my lord, somebody was paid, my lord, 6 lakhs after in the year 2024, that is how she has come up, my lord.
Well, that I understood. But the fact
So now, if now suppose I have not filed my written statement and not, my lord, objected to the condonation delay, whether that ground, my lord, could have been a ground for condoning the delay, my lord. That reason that because somebody else was later on paid a higher amount, that is why, my lord, I have.
Mr. Chaudhary, the problem arises is if you raise that issue out here, you are on a very thin line.
I know, my lord. Now, my lord.
And with this thin line,
I know, my lord.
At a later stage, you will be in problem.
My lord,
Find out
that is why what I say, my lord.
No. Find out whether there is a provision similar to Section 7A bracket 4, which is there in the Employee Provident Fund Rules 19.
My lord, I have read your judgment. After, my lord, doing my research on all these things.
I'm not read it. I will deliver the judgment only.
No, my lord. There was a judgment in the year 2023. That is, my lord, 2023. I can tell your lordship, my lord. After, my lord, having read that, I stopped myself. That is, the title is on the death of Prahanna Kumar Bormon. That was a matter in respect of, my lord, non-payment of pension, family pension. Your lordships had the opportunity to go into that, my lord. And there in one line of the judgment, your lordships has stated that for the purpose of, my lord, condonation of delay in matters of payment of pension or gratuity, these are all continuing wrongs. So,
No,
perhaps
I need not say there are lot of other judgments also. But whether the gratuity also.
so that is why at this stage, my lord, now, my lord, to cut a long story, because even if, my lord, if I walk on the thin road and I succeed, my lord, I will be remanded back with the, my lord, what I am anticipating is I'll be remanded back, that, okay, they will file a proper application for condonation of delay. That will be considered after I give my reply and all, and ultimately what will happen?
No, that
That
cannot happen. That
my
can-
meter will go on, my lord.
You can, but the only problem is, I'm only looking into how do you deal with an ex parte order?
So that expertise, that illegality I am pointing out, because after, my lord, this Pathapathis, my lord, the judgment of the Supreme Court, my lord. After Pathapati Subba Reddy, my lord, there were some, my lord, guidelines given in that guideline.
Okay, so you are not going on appeal because you have to deposit certain amount.
My lord. Not only that, my lord. Because, my lord, may I pray, my lord? My lord, to cut a very long story short, my lord. My lord, what I will pray before your lordship now, my lord, kindly see. That delay of 4 years is on account of that employee, my lord, not on account of me, because as per our rules, on the then and there on superannuation, I had paid the amount, my lord.
You have not filed your written statement.
No, but I understand, but she came up after 4 years. So, my lord, whether, my lord, after 4 years, when the applicant comes up without any fault on my part, my lord, whether she will be entitled to interest from the day on which she is superannuated. Now,
Interest.
Interest now has been calculated from the day when she superannuated, when for the entire period of 4 years,
But
I was not at fault.
what you are submitting out here
My lord.
is not there. Before those authorities.
My lord, whatever happened,
How do I, in exercise of my social jurisdiction,
my lord,
find any illegality in that order, and for the first time appreciate these facts?
Not facts, my lord. This is there on record. This is, I'm not disputing it. I am only saying that, that is why I have raised.
No, therefore I'm saying,
my lord,
the question is whether it was 1 lakh. Your basic case is this.
My lord.
Look here, at that point of time was 1 lakh.
Hmm.
Now, in view of some centenary of 75 years or whatever maybe, we have made it now 6 lakhs. Now she having come to learn. So now what she has done is she filed an application that although I have retired in 2021, but I have not been given my due gratuity.
My lord.
And therefore, so your basic crux is, at that point of time, it was 1 lakh. So we gave her 1 lakh and she was satisfied.
And you accepted and satisfied. Yes.
Now you cannot come up when a new fact has come, because we enhanced the gratuity as per the terms and rules of there only recently.
Recently, 2024.
That is a fact which is not there on record.
No. I am not a judge. Just for the matter of information to your lordship, my lord, I have submitted that. What I am submitting on law is by exercising powers under Rule 10 of the Payment of Gratuity Act, where the period of limitation was 90 days and the power of condonation was given. Whether condonation could have been just done at the stroke of the pen without there being a petition on record to condone the delay.
Is
and
it
with a notice
required
to me.
as per Rule 10 for filing a petition? You have to take note of that this is a cautious judiciary.
Yes, madam. But there are judgments which says, my lord, there are judgments, my lord, which says even before a quasi-judicial authority, it is all the more required that if you do not file a petition for condonation of delay, then ultimately it will be said to be, my lord, non-executive. Bombay High Court.
Bombay High Court, I can't agree with that.
Maybe, my lord.
No, because of the fact that,
my lord,
see, limitation is on a different thing.
I know.
Limitation is on a different thing. But here is the case where it's a question of quasi-judicial authority. my lord, limitations. See the you see the right of to get the gratuity, pension, and all these things as the conflict.
No, that is why,
Obviously,
my lord.
recently you might find one judgment I forgot. Very recent judgment. Some payment.
My lord.
I think it's a Supreme Court judgment. I think you'll get it 4-5 days before in life law.
My lord.
You just find out there is one judgment to the effect that he approves after 10 years or something.
My lord.
The court said that it's although it is a continuing wrong and all these things, but then also he is not entitled to. Very recently, haven't you?
My lord. I am now relying upon Pathapati, my lord. That is 24. Pathapati has laid down certain guidelines regarding condonation. And there it says that when somebody wakes up saying that, my lord, and even yesterday, my lord, live law, that is the state of Kerala versus NV, my lord, Ramanna, something like that.
Yesterday.
Yes, yeah, yesterday, my lord. Yesterday. NB Ramannath. In Pathapati, some guidelines were laid down by which, my lord, it was stated that, my lord, if somebody wakes up later on, my lord, seeing that somebody has been given, my lord, some benefit, then that will not be a ground. Pathapati is, my lord, 20.
No?
My lord?
It is the concept of fence-sitter.
Yes, yes, fence-sitter. And in this judgment passed yesterday, that Kumbhakarna and Rib Van Winkle has been Kumbhakarna and Rib Van Winkle has been referred, my lord.
This is by that's a Supreme Court judgment, no?
Yes, a Supreme Court judgment.
Yes.
Yesterday, my lord.
They have referred to these two books.
Yeah,
one is
Kumbhakarna and Rib Van Winkle. Because Rib Van Winkle.
At 2 o'clock.
Yes, my lord. Because ultimately, I say my final prayers, cutting short everything is, my lord, kindly reduce the amount of interest, my lord. I'll go and pay them, and that will be the end of the matter.
We'll see.
At paragraph 9, my lord, the last but one page.
Where is the provision by which it has to be moved within
90 days.
90 days? Where?
That is rule 10, my lord. Rule 10 of the payment of gratuity. Provided the controlling authority may accept any application under sub-rules on a sufficient so and so.
Rule 10 of the 72 rules.
Yes, my lord. After sub-rule 3, my lord, the claimant, employee, nominee or legal heir as the case may within 90 days of the occurrence of the cause of action for the application apply in form and to the controlling authority for issuing a direction under sub-rule subsection 4 of section 7 with as many extra copies as are the opposite parties. Provided that the controlling authority may accept an application under this sub-rule on sufficient cause being shown by the applicant after the expiry of the specified period.
What is the sufficient?
Now,
cost for-
now if your lordships comes to page 61,
61
61, my lord.
of 554.
Yes, sir, the item number 17, my lord. Item number 17, my lord, page 61. After the heading findings, your lordship will come to the last line. The claimant stated that the matter came to light when one of the employee of another establishment expired and the nominee received approximately 6 lakhs as compensation, which included gratuity amount. Now, this was the only ground espoused for the purpose of condoning the delay, my lord. And if that be the ground, my lord, this is one judgment that Patapati, my lord, 24, paragraph 25, clause 6 to the Hajiola. Paragraph 26, subclause 6. My lord, I have not marked it.
Paragraph
26, my lord, subclause 6. Some guidelines are given there on which condonation is not to be allowed.
No, this won't apply. This judgment would not apply. This is for the limitation act.
Limitation act?
You see, if you read section rule 10,
my lord,
says that a person is required to file within 90 days.
Yes, my lord.
The application.
My lord.
And the proviso say that the court may, on sufficient reasons,
Being
may
shown.
accept the statement.
My lord.
There is no requirement even for filing an application.
No.
Now, if we go to that judgment, Seshnath,
my lord,
the Supreme Court, while dealing with Section 5, categorically say
my lord,
that, and more particularly at paragraph 61, that
if
there
the
is no
ground,
even requirement of a filing.
if the grounds are there, if the grounds are there, that is enough.
Grounds are there. Yeah, the grounds have been duly mentioned. Rightly or wrongly,
my
the
lord.
grounds have been mentioned.
My lord.
You were given an opportunity to say, have a say.
I
You
did not
not.
say.
So therefore, that question of Rule 10 being there, because here they, I would have understood there is no, because here he said that OP was given an opportunity.
Yes,
time
it,
to
it,
so
that
and
is
so.
that is there. I did not file.
So
I do
there
not know.
they-
I don't know what happened, my lord. And so that is why, my lord, with this I am here before lordships, and that is why I stated, my lord, that without going into all these things, if your lordship says, my lord, that from the date of the order, if you calculate the interest, my lord, I'll be happy that whatever she gets, my lord. Because for these 4 years at least, my lord, because there is a bar, my lord. If, my lord, the fault was not on the part of the employer, then, my lord, Rule 7, Section 7, my lord.
Okay, you pay the gratuity.
I'll pay the gratuity.
Seven.
Stay is subject to payment of gratuity.
Yes, the principal amount I'll pay by.
The interest is state.
Yes.
7(3)(a) says, Malak, that interest is calculated from the date of the gratuity become payable until the date is finally paid.
Yes.
So it is in the act itself, Malak.
Understood, but the thing is, if you approach the court
Not
later on, because there, at that point of time, they had a scheme
Lordship.
of having it at 1 lakh, which may be right or may not be right. We'll
Right.
consider that.
Yes.
But the fact that the gratuity, let them pay the gratuity.
Yes.
Malak.
Yes.
But
Principal amount may be.
Yes.
principal,
Yes.
let them
Yes.
pay the other ways.
My lord, within a period of 6 weeks, my lord, we'll pay the. Within a period of 6 weeks, my lord.
Before that, the matter would be disputed. You can't go for that 6 months. This is not that.
1 week, man. Because my they'll have to collect the
You
funds.
pay within 2 weeks.
My lord.
Issue notice making it returnable on 8th of December 2025. This is the time I'm giving, more than, not more than 10. That is 1 month, 2 months, 2.5 months.
My lord, if your lordship says, my lord, that from the date on which this order has been passed.
I'm not fine. That would be an ex parte order,
My
ex parte judgment, which I'm not saying. So I'm saying the interest. Because if interest is paid, principal is paid, then the interest is paid, then therefore there is a no problem of an interest on interest.
Yes.
Issue notice making it returnable on 8th of December 2025. Miss Mrs. Yuda, the learned additional senior government advocate, appears accepts notice on behalf of the respondent numbers
One and
1 and 2. Extra copies of the petition be served upon her during the course of the day.
My lord, by tomorrow, my lord.
By tomorrow. Tomorrow is Saturday. How
By
can you serve?
Monday, by Monday.
By no. You gave it
My lord,
today.
I deliver, I can deliver.
When there is an interim
Yes,
order,
yes,
24
I know,
hours
I know.
apply. Although I'm not in bench one, but I follow that.
Rule 3 applies everywhere, my lord.
During the course of. As regards the respondent number 3, steps be taken by way of speed post. In addition to that, the petitioner is also within by Monday. As regards.
My lord, I have handed over the copy.
The petitioner is further directed to take steps by way of is also directed to effect service upon the respondent number 3 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. The petitioner herein have challenged the order dated 4/3/2025 passed in LTC case number 42/2024, whereby the respondent number 2 have arrived at the finding that the respondent number 3 is entitled to an amount of rupees 9,29,385. It was further directed that the said amount of gratuity payable, which is 9,29,385, shall also continue to accrue interest at the rate of 10% per annum from the date it fell due as calculated above. The learned counsel appearing on behalf of the petitioner submitted that the respondent number 3 retired on 31/3/2021. And at that relevant point of time, the gratuity which was fixed as per the terms and conditions of the appointment of the respondent number 3 was rupees 1 lakh. The respondent number 3 thereupon, upon her retirement, had accepted the said amount and raised no issue till filing of the application
On 3/7.
in the year 2024. Under section 7(4) of the Payments of Gratuity Act 1972. The learned counsel appearing on behalf of the petitioner submitted that as the respondent number 3 had accepted the same accepted the said amount and did not raise a dispute raise any dispute till the year 2024. The question of the respondent number 3 being permitted to file the said application by the respondent number 2 was not in accordance with the provisions of the Payment of Gratuity Act 1972. More so in view of Rule 10 of the Payment of Gratuity Central Rules 1972, which stipulates a period of filing of the application within 90 days. Additionally, the learned counsel appearing on behalf of the petitioner further submitted that the respondent number 2 in the impugned order could not have imposed penalty, taking into account that the adjudication was done only by the order dated order impugning the instant proceedings, could not have imposed interest. Till the date of the adjudication, that is adjudication made under section 7(4) of the Payment of Gratuity Act 1972. And as such, the imposition of the interest for the period from the date of retirement of the petitioner till the passing of the order on 4 till 19/2/2025 was rehorsed the provisions of the Act of 1972 and the rules framed therein under. Per contra, Mrs. Yudas, the learned additional senior government advocate, referred to section 7
3A.
3
A.
7(3)(a) capital A. Which stipulates that the interest is payable, which referred to section 7(3) capital A and submitted of the Act of 1972 and submitted that statutorily it has been mentioned that the person concerned, the employee, is entitled to interest from on the amount of gratuity which becomes payable to the date on which it is paid. And therefore submits that the impugned order does not call for any interference. This court have given an anxious consideration as to whether any interim order is required to be passed. Further, this court have also taken note of that an execution application has also been filed before the respondent number 2 by the petitioner, by the respondent number 3. And notices have also been issued to the petitioner. Considering the above, it is therefore the opinion of this court that the petitioner had been able to make out the point, have been able to make out the prima facie case as regards the imposition of the interest and the date and would require further deliberation. However, this court is of the opinion that as the petitioner have not filed any, is of the opinion that there should not be any interim directions insofar as payment of the amount of gratuity adjudged in the impugned order. It is seen that by the impugned order dated 4/3/2025, the amount of gratuity it has been held by the respondent number 2 that the amount of gratuity the respondent number 3 is entitled to is rupees 6,63,846. Accordingly, this court passes the following interim directions. Number 1, the petitioner is given the option, the petitioner, the proceedings pending before the respondent number 2 in connection with non-compliance to the order dated LPG bearing number LPG.42/2024/1151-1152. This is a different order.
Same, my lord, for both.
Huh?
Rita Anthony, my lord. Rita Anthony and the management of the.
Why is it mentioned at 8/5? I hope you have not made the mistake of enclosing a different document with me.
No, my lord. Oh, the 4/3 was modified as 8/5 because initially they made some calculations, then that was wrong. It was pointed out. Thereafter, it was recalculated.
Where?
Is there, my lord?
Oh, this one.
Yes, my lord.
Oh, 8/5. Dated 8/5/2025. It state subject to the petitioner paying the respondent number 3 the amount of rupees 6,34,123, which is the gratuity held to be entitled to by the respondent number 3. Number 2, there shall be a stay in respect to the interest. You see, you have been only asked to pay that only.
No, my lord.
Yes.
Because that. No, my lord.
Type copy and Annex 5 has been passed, whereas the said order was passed ex parte as the AR, whereas the computation of gratuity has been drawn as so and so, whereas so and so clarified the demand, basic so and so, so and so. Now, therefore, since the management has agreed to pay the outstanding amount of gratuity to earn in the light of the clarification and in the interest of ensuring a just and accurate determination, the authority deems it proper to revise the relevant portion of the year to the reflect the correct last earned wages as follows. Revised last earned wages plus DA so and so, length of service demand, amount of gratuity entitled demand. All other findings and calculations are remain as the revised year.
It is actually along with interest, it is 9,29,385 as apparent from page number 63.
But this has changed, nah?
That may be some typographical error on their part, but this is what they are claiming, my lord.
No, earlier it was found that 6 lakhs, it should have been more.
Actually, it is calculation was 7,63,846.
No, it was 7, not 7 lakhs, yes.
So out of that 1 lakh, because I had paid at the time of superannuation, that they have deducted. So after deduction of 1 lakh, it comes to 663,846.
But later on, it was changed to 734 and minus 1 lakh. So it is 634, 12634. The payment as regards the second one is also same.
Same, my lord. Only the rate is different, names are different.
Interest portion is state till next.
I'm different. So now I'll pay 663,846.
In one, and then the other one, whatever will be.
Whatever.
The same thing.
Same.
It will depend.
Yes.
It is mentioned. Also.
Yes.
It also there also 85.
That is also, my lord.
Yes, fine.
At page 60, page 63.
But your case is on very.
At page 63, it was determined that
your case is very, very bad. Not bad.
I am walking on a tightrope without the balance, my lord. I know what to do, my lord.
So
and the other case, it is, my lord, at page 63, my lord.
The remaining, if it is being settled,
my lord,
when the other side appears.
My lord.
Well,
I think she will get, my lord, because
No,
it
she will
is, it is on the part of the management, my lord. They are.
No, I am only paying the gratuity so that it stops the interest.
my lord, my lord.
She is entitled.
These are poor educational institutions, my lord, NGO. These educational institution, these are non-profit making NGOs, Holy Child School, my lord. So their fee structure and all, which is the only source of revenue, is also very less in compared to the fee structure of all other private schools in the state of Assam. So that is why that is the pinch, and why I wanted to settle is that if it goes on.
Is there an exemption possible under the 72 Act for those people?
No.
It makes no sense.
Item 55 and connected item production list formation.
No.
An application filed by the petition applicant for insertion of for arraying, for impleading the MS Prabhabi as well as its partners as parties to the accompanying writ application, taking into account that their presence would be essential for the purpose of just and fair adjudication of the petition. This court impleads the MS Prabhabi as well as its partners the names of whom have been mentioned in paragraph number 3 of the instant application as petitioners to the accompanying petition, and they are arrayed as petitioner number 2, 3, 4, and 5. The counsel appearing on behalf of the petitioner is directed to make necessary changes in the cost title, is directed to file a fresh memo of parties before the registry of this court by Tuesday, and on the basis thereof, as well as the order passed today in the instant application, the registry shall make necessary changes in the cost title and update the same in the CIS. Now come.
My lord, I'm submitting some list of dates, my chronologically, and my lord, the tender document also that is required, my lord.
Now tell me the bank guarantee. Now tell me the bank guarantee, whether the bank guarantee is negotiable or not.
What's it?
The bank guarantee which has been given, he has given a bank guarantee. The bank guarantee categorically mentions that, where is that guarantee? The guarantee categorically says that in consideration of so and so hereinafter referred to so and so, so and so, so and so. We ICICI Bank have only one branch of so and so. Then where it is mentioned. Yeah. Have awarded Arab Engineering Consultants Limited, formerly Arab Agent and Consultants in consortium with so and so, as so and so, and another address at so and so, which expression shall so and so of the one will be accepted by the result so and so. That's it. Now, what is your grievance, Mr. Gogoi, in this case?
Lordship, here, Lordship, basic, Lordship, they have not submitted, the successive bidder has not submitted the performance guarantee. Lordship.
This is the performance guarantee. Annexure, what do you mean? This is the performance guarantee.
Performance guarantee was submitted, Lordship, new entity, in the name of new entity, Lordship, lead member of the new entity, Lordship.
No, this is not a new entity. It is a change of the name. The company remains.
Change of the name, otherwise, Lordship, the terms and condition of the Lordship, that RPF is not permitted with this, Lordship. So, Lordship, may kindly come to page 101, Lordship.
Yes. Yes, which one?
Lordship. 2.1.2, Lordship. Madam, may kindly come directly to the Lordship. 2.1.2, first paragraph, last two line, in case of bidder is a consortium, it shall comply with the following additional requirements to be eligible. Then Roman 4 Lordship. Members of the consortium shall nominate one member of the, as a lead member. The lead member who shall have minimum 51% of shares of the consortium, and the nomination shall be supported by a power of attorney. And as per the format of the RFP lordship signed by all the other members, the duties and responsibilities and powers of such lead members shall be specifically included in the joint bidding agreement. It is expected that the lead members who would authorize to incur liabilities to receive the instruments and payments for on behalf of the consortium without prejudice to the joint and several liability of all the members of the consortium. The lead members shall represent all the members of the consortium and shall all times be liable and responsible for discharge of functions and obligations of the general consultant. Then my lord,
You come to 102.
102
Roman 8.
Roman 8 lordship. Roman 8 lordship, no changes in composition of consortium will be submitted to the authority during the selection process and during subsistence of the project lordship. Here lordship, during the subsistence of the project lordship, they have changed the lead member. Then lordship, the joint bidding agreement was also not done by them. Joint bidding agreement was. It was also as per my instructions, my lord, that the lordship has already perused it. That is condition.
But how can he give now a bank guarantee or a performance guarantee in the name of RB Associates, Architects, Engineers and Consultants Private Limited when it had changed?
Loss. They should not change lordship without informing the railway authorities lordship. Before changes, they have never informed the railway authority lordship.
But there is one letter being written by you. Where is that document?
That letter is there. That letter lordship does not change the
Yeah.
of the bidding document lordship.
Yeah,
That
kindly come
negotiation
to
letter
page
lordship.
82.
Negotiation letter lordship.
Name change post conversion from private limited to limited. This is by NF Railway. This has been informed. When did you issue the letter of intent? 22
5 26 25 lordship.
Huh?
They have sent it 5 25 lordship.
25/5
Lordship.
2025.
Lordship.
But prior to that, they have informed at page 82.
They have informed lordship, but lordship prior permission they have not taken lordship.
Now we are pleased to inform you that as a part
is
of our
there.
strategic growth and organization change, our company's
After
name and
sending the
office
lordship,
change from so and so, formerly known as so and so, to RB Engineers Limited, effective from 6th of February. The change is a result of successful conversion of a company structure to so and so. Please note the following points regarding the change. Our GST number so and so remains unchanged. Our CIN number has been updated from so and so to so and so. We are in the process of updating our bank accounts and other so and so. However, all existing contracts, agreements, so and so dealing and any other legal endeavor with you under our previous company, namely so and so, will continue to be valid and enforceable under the new company, namely so and so. All the bank guarantees issued by the banks will be valid. We therefore request you to update your records in here. Now, pursuant to that, did you update the records?
No, Lordship.
No, it seems so because that is the reason. Kindly see that.
1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1
Where's the termination letter? Yes.
Lots.
Kindly come to paragraph number 4. Page 85.
Lordship.
Read paragraph 4. Further as
It
mentioned
starts
above-
from page 84, Lordship.
Hmm.
Further, as mentioned at 3 above, his office has informed that the name of the selected bidder is not matching with the name of the mentioned in LOA, Lordship.
No, read it.
Lordship. In response, this office received a letter referred at 5th through email 29 July 2025 as well as a post on 4th August 2025 about the official changes, Lordship. Of
From
the name
RV so and so.
selected bidder so and so, so and so, so and so. It is on Lordship 29 July 2025.
Now, what about this document which has been shown as received on 7/5,
Lordship?
page 82? That is why I'm saying.
Page 82, Lordship. That I cannot say today, otherwise there
Because
still
you
is
say-
still is there, Lordship.
Because paragraph 3 says that you have, after everything has been done, they submitted that document. But kindly read it. Consortium as so and so, so and so. By this time, the stipulated date of submission of the 15 days is over, and from the date of LOA with interest after grant of Iman has been so and so. It has been observed that although the instant bid is in the name of so and so in consortium are submitted by the authorized signatory of Iman, being the lead as declared by the joint bidding agreement, but later the name of RV disappeared from the IREPS portal. And,
They have uploaded
and
it.
this name is found replaced by so and so wherever possible after closing the bid. But the name of the selected in the unknown in the financial tabulation statement. Now, how did this change take
These
place?
things they have uploaded, Lordship. It is not uploaded in the railway portal.
No,
Lordship.
no, they disappeared from the ISO. Now, here he says,
Now, as and when they have uploaded their new entity, Lordship, it is automatically disappeared the earlier entity, Lordship.
no, what do you, because you have to answer this, because one of your grounds for rejection is those paragraph 3 that you did not know. Now, page 82 says otherwise.
Page 82, Lordship, that is there, Lordship. It is received on 7/5/2025, Lordship. It is there, Lordship.
Because there they categorically inform. And in spite of that, you issued the. This is a very important document.
That
Now,
is
who
the
has
otherwise,
received it?
otherwise, Lordship, before changing, they have to take permission from the railways authority, Lordship.
So that, no, that is very good. I accept everything.
And
But
even, Lordship, the LOAs issued in the name of the earlier entity, Lordship. Now we cannot go
Mr.
revert back to
Gogoi,
the
that is very much understood.
Lordship.
But when did you issue the LOI? 26/5.
Lordship.
26/5. But prior to that, if they have duly informed, then also you have issued the LOI. Now explain me there the problem. That is the only question I am asking.
Lordship.
If I would have understood this document not there. Now, you do not mention in paragraph number 3 about this document. You say that this information came only on
regarding-
27/5.
Regarding that information, I have to obtain whether it was received by the proper authority or not, Lordship. Whether it was received by the proper authority or not. That part I have
This
also
is
done.
being sent to the railway, NF Railway Construction,
It
FLS.
is there, Lordship, who have received it, who have seen, seal is, who have put the seal, Lordship. That part I have to obtain instruction. Otherwise, it may be, Lordship, if the proper authority has received this, after knowing this, I will not submit anything, Lordship.
Because if he has done it,
Lordship.
proper authority, and then issue the LOI,
Lordship.
then the question
Then
becomes a different.
something is there, Lordship.
It takes a different color.
That defined.
But if this is a document which have not been received,
Lordship.
then it was only received, only information was given on 29/7.
Lordship.
Then the
Then
question
it stays totally defined, Lordship. Otherwise, if it is placed before the proper authority, not that part I have to obtain instruction, Lordship.
Chalo.
Lordship.
We do one thing,
Lordship.
we issue notice on this. And what is the stay you are asking, Mr.? You're asking for stay?
My loss. No. Upon that letter, my lord. Termination notice.
No, that you cannot ask for termination stay. That I can't make a dead man alive. by stay.
My lord, that will, if
Floating,
they are-
finalizing
if
of
they are
proceeding
rested from-
with any new tender for the subject and 56 when we'll say that if any tender is being issued,
Lordship,
that shall be out, subject to the outcome of the
Lordship, no
litigation.
issue, Lordship.
Liberty given to the petitioner to participate without prejudice to his contentions. All these
Lordship,
things
Lordship.
will
In the
remain,
meantime-
and I'm having it only
They
on
should not-
October.
And they should not forfeit the bid security. Bid security should be forfeited. by-
Ah,
The bid security should not be forfeited by them. And there
it's not the prayer.
That the submitted bid security, the submitted bid
Where is
security is forfeited. Forfeit করবে, they want to forfeit it.
There is, there was.
Mr. Sharma, they have already forfeited. They have already forfeited.
No, they,
How do I say that? They've said that you will be entitled to the release. They will refund the money.
Lordship,
This is money after all.
Lordship. Till the order was passed, but till that not forfeit. Order has been passed, but till that
Bid security is, how did you submit the bid security?
by bank guarantee.
No, this one is bank guarantee.
Bank-
Performance guarantee is bank guarantee.
That was also bank guarantee.
No. Security has been done. How did you give the bid security? Show me.
Here it is not mentioned.
Hey, this is not your prayer also.
Loss.
Don't come up with that.
Even if success, he automatically get back.
Ah, you'll get that. Don't worry.
Not the issue, Lordship.
That is not the issue. Okay. Issue notice. We'll like to finish it up before, just before Diwali.
Lordship, Lordship.
Let him be happy and get an order. Good.
Lordship.
Issue notice making it returnable on 16th of October. I'm having it on Thursday so that we can finish it off. Mr.
They need to be that till then they should not a fresh tender.
No, I don't give stay. This type of cases, I don't give stay. If you want, you will get everything. I'm making it subject to outcome. I'm allowing you to participate without prejudice.
Even Lordship, now we are putting it, it will take some time, Lordship. It will at least
Don't worry.
keep.
Mr. K. Gogoi accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the petition be served upon him during the course of the day. Extra copies of the petition be served upon him by Monday. With the change. Okay, you make it with the change.
Probably Lordship, they have to change the internal paragraph also somewhere, they have to change it. Lordship. Only
Somewhere petitioners.
Only
between petitioners.
No, that you can't change it. That is an amendment.
That is an amendment, they have to.
Maybe a wrong mistake.
Lordship.
Petitioner will take it as a JV.
Lordship.
Okay.
No, Lordship, that is.
We are not. By Monday. By incorporating the changes in the cause title. The petitioner herein is aggrieved by the order dated. What is the date of the order? 3/9/2025. Whereby the respondent authority have cancelled the letter of intent and terminated the contract on the ground that the petitioner, on the grounds and reasons mentioned in the said communication dated 3/9/2025. The issue involved in the instant proceeding is, as would appear from the facts, is that a joint venture in the name and style of RV Associates, Architects, Engineers and Consultants Private Limited in consortium with Prabhavi, submitted the bid for where's your LOA?
Page 22.
Huh?
Page 22.
Submitted the bid for appointment of general consultants for NF Railway Construction Organization Headquarters. Full stop. The said bid was submitted on 15/11, nah? Mr. 15/11/2024, if I'm not wrong. That day you said that.
Bid is 5/11/24.
5/11/2024.
Negotiated bid is 26/5/24.
While the said process of settlement of the bid, while the said tender process was ongoing, the company, namely RV Associates Architect, Engineers and Consultant Private Limited, which was a private limited company, was converted into a limited company and was named as, and with the name RV Engineering Consultants Limited, on the basis of was converted into a public company, a limited company, and a certificate of incorporation in that regard was issued on 6/2/2025 by the Register of Companies of the Government of India, Ministry of Corporate Affairs. It is the case of the petitioner that on 5/5/2025, the petitioner, the petitioner duly informed the NF Railway Construction, FLS about the change which was duly received on 7/5/2025. Thereupon, the respondent have also invited the petitioner, who was the lead consortium member for negotiations, and on 4/6/2025 issued the letter of acceptance.
For negotiation, 22/5/25, they have called for negotiation 22.
Huh? So this is a letter of acceptance, na? Page 22.
Regarding negotiation 22.
That is okay,
lost
but yeah, on 4/6/2000, had issued the letter of acceptance. In terms with the letter of acceptance, there is a requirement of submission of the performance security which is as per clause 1.1.1 of KIT of RPF tender document. Within 15 days without interest and up to 60 days with interest. The petitioners admittedly did not submit the performance guarantee within the 15 days window, but submitted the performance guarantee in the form of a bank guarantee dated 23/7/2025. Wherein also there is a due mention about the petitioner company being earlier known as RV Associates Architects, Engineers and Consultants Limited. The learned counsel appearing on behalf of the petitioner submitted that in spite of the respondent authorities having clear knowledge even prior to issuance of the letter of acceptance that the company, the petitioner company, was that RV Associates, Architects, Engineers and Consultants Private Limited name was officially changed to RV Engineering Consultants Limited, and there was a successful conversion of the said company from private limited to limited company. As would appear from the receipt on of the communication dated 5/5/2025 on 7/5/2025. And thereupon had issued the letter of acceptance. The question of termination on the ground of being not intimated of the change during the process of selection is on the face of it perverse, and it appears that the same has been done with vested interest. The learned counsel appearing on behalf of the petitioner further submitted, this is a case that the termination is required to be interfered with, as even there was no notice being provided, prior to the termination. Per contra, Mr. K. Gogoi, appearing on behalf of the railways, submitted that in terms with clause 2.2, 2.1.2, Roman 8, there cannot be a change in the composition of the consortium during the selection process, as well as during the subsistence of the project. The learned counsel submitted that it was only on 29/7/2025 the respondents were intimated about the change in the composition of the lead member. He therefore submitted that had the respondent authorities knew about this change, the question of issuance of the letter of acceptance on 4/6/2025 did not arise. Taking into account the above, this court is of the opinion that the stand
Notice was given, Lordship, kindly peruse page 38. Lordship. Before termination, notice was.
he says,
Page.
this is his submission,
Lordship.
not my finding.
No.
Taking into account the said submissions, this court is of the opinion that the stand of the respondents is required to be brought on record so that this court is in a position to decide the issues involved and is in a procedure, is in a position to adjudicate the dispute involved herein. The respondents, therefore, are directed to bring on record their stand by filing the affidavit on or before 13th of October 2025. It is further seen that the petitioner have sought for interim directions. The interim directions so sought for were the interim directions so sought for, but they were to state the operation of the termination notice dated 3/9/2025, as well as to restrain the respondents from floating, finalizing, or proceeding with a new tender for the subject project. This court have duly perused the communication dated 3/9/2025. In the opinion of this court, the said communication cannot be mentioned to be a notice. Rather, the said communication is the termination, amounts to termination of the contract. And as such, the question of staying the termination does not arise without permitting the respondents to have a say by way of filing the affidavit. In respect, as regards the plea, as regards the prayer, that there should be a stay to the floating, finalizing, or proceeding with a new tender, this court at this stage is not inclined to pass any such order. However, it is observed that any new tender, if floated, shall be subject to the outcome of the writ petition. This court further permits the petitioner to participate in the said new tender process, if so floated, and such participation shall be without prejudice to the rights and contentions in the present writ petition. Yes, what is this?
My lord. Here, my lord, petitioner is aggrieved, my lord, at the arbitral cancel of the allotment, my lord, petitioner, my lord. Here, my lord, petitioner had participated, my lord, in the, my lord, outlet distributing by the IOCL, my lord. Here, my lord, as per the requirement, my lord, petitioner submitted all the documents, my lord. But subsequently, my lord, the IOCL had cancelled that the land which was owned to the, my lord, IOCL, my lord, that is not partitioned, my lord. That is not partitioned, my lord. There is the objection, my lord, that co-partner has not issued no objection, my lord. that leased land, my lord. Actually, in fact, my lord, the land, my lord, which was on lease, my lord, measuring 1 kata 4 less, my lord. That was lease deed was executed, my lord, after obtaining the NOC from the concerned authority, my lord. And at the time of issuing NOC, my lord, the no objections were obtained from the, my lord, co-partners, my lord. Now they are raising the issue and no, you have not annexed that co-partners, no objection, my lord. On that whole ground, my lord, they have cancelled, my lord. Even, my lord, there is a clause, my lord, in the Gosar, my lord, that 90 days time should be given, my lord. But that time was not provided, my lord. That option was not given, my lord.
90 days time for what?
For providing alternate land, my lord. If they are not satisfied with that land, my lord, proposed land, my lord, they can ask the, my lord, beneficiary, my lord, to provide or show alternate land, my lord, within 90 days, my lord. That was not even given, that opportunity was not even given to the people, my lord. And my lord, here, my lord, lease deed was executed, my lord, after obtaining the NOC, my lord, from the district.
Kindly come to page 23.
23, my lord. Yes, my lord, I'm on 23.
A.
Yes, 23, my lord.
Yes. Other conditions with respect to offering land are under. Last slide.
The land should be available with the applicant as on the date of the application and should have minimum lease for 13 years, 11 months, my lord. Here, my lord, the land has been all
Read.
my lord, as advertised by respective oil company from the date of or after the date of advertisement, but not later than date of application. If the offered land is on long-term lease and there are multiple owners, then lease deed should be executed by all the co-owners of the offered plot. In case lease deed is not executed by all the co-owners, thus lease deed shall be treated as invalid.
So this is the basis.
This is the basis.
Now, on the basis of that, now let us see the land. Who are the owners?
Now, my lord, that come to the my lease deed, my lord. It is.
Where is that?
Lease deed, my lord. Lease deed, my lord. 107, my lord.
Huh?
107, page 107.
107.
Yes, my lord.
Now, show me who is the owner of the land.
Coming, my lord. 107 is the, my lord, and the NOC, my lord, your lordship.
Where is the land documents?
Land documents, my lord, your lordship will find, my lord, at page, my lord, page 127, my lord.
127,
my lord. That's one thing, my lord.
So this land belongs to
on Mubarak
in
Mullah
terms of
and
the order passed in mutation case number Iman, the land covered by tag number is mutated in the name of Mubarak Mullah, father
late Abdul Rahman
so and so
and
Mufizuddin inheritance in place of Abdul Mullah. Now, who was that?
Mufizuddin, man.
What was the date on which Mubarak Mullah, in terms with the order dated Iman by the circle officer, land covered by tag number Iman, is in the name of Mubarak Mullah, so and so by virtue of inheritance in place of Abdul Mullah. Who has executed this deed?
Mufizuddin, my lord.
Who is Mufizuddin?
Brother of Mubarak Mullah, my lord.
Huh?
Brother of Mubarak Mullah, my lord. That is brother of
brother.
Yes, my lord.
How can he do so?
My lord, that land, my lord, that land was mutated against both the name, my lord.
But it has been only name of this person is there.
No, my lord, there is
mutated in the name of Mubarak Mullah.
And another, my lord. Can you see another?
And where is the another?
Mubarak Mullah, father late Abdul Rahim Rahman
and Mufizuddin Mullah. So it is in both names.
Yes, my lord.
Then,
my lord, that land, my lord, misery, my lord, for 3 biga, my lord, more than 3 biga.
So,
and the Mufizuddin, my lord, he has leased 1 biga 4 less, my lord, of his own portion, my lord.
So,
now, my lord,
1.4 bigha, my lord.
It was the term of the contract. You knew it.
My lord,
How do I help you?
my lord,
How
that,
do I help you?
my lord, kindly see the NOC, my lord. The NOC, my lord, which was issued by the competent authority, my lord. Kindly come to the page 106, my lord. 106, my lord.
Yes.
This is the NOC, my lord.
For the lease.
Yes, my lord.
So
This land, my lord, measuring 1 bigha, 4 kata, my lord. And it was issued in favor of, my lord, Mufizuddin Molla, my lord, against his own portion, my lord. 1 bigha 4 less, my lord. After issuing this NOC, my lord, he has executed the lease deed, my lord.
I can't help it. That case.
My lord, the NOC, my lord, which was issued, my lord, definitely, my lord, without no objection of the other co-partner, my lord, NOC is not issued, my lord. And is it the issued, my lord, as per the guidelines of the Assam land regulation, my lord?
That case.
Yes, my lord.
That case.
Otherwise, my lord, another option, my lord, here, at least, my lord, he should be given 90 days time.
For what?
For showing alternate land also.
Show me that.
Page 23 still, my lord.
Yes.
Where?
Where?
My lord, land applicable to all the categories, my lord. Under clause 4 of 4, my lord. Here, my lord, kindly see, my lord.
Land offered by all the applicants under group 1 and is found not suitable, not meeting requirements, then these applicants under one along with group 3
Yes, my lord.
would be advised by the OMC to provide suitable lands in the advertised reserve within a period from the date of issuance of the intimation letter to them through so and so. In case the applicant fails to provide suitable land within the prescribed period, or the land provided is found not meeting the laid down demand.
Here, my lord, petitioner had applied under category 1, my lord. At least he should have given a chance, my lord, to show if they are not satisfied at all with that focused land, my lord. He could have shown the alternate land also, my lord.
This will be when you come again to group 3. Because the word is along with.
My lord.
They should have said that, you see, group 1, group 2, along with applicants under group 3. So a person who is in group 1 or who has a MOU in respect of group 2,
right,
they do not meet the criteria, then they would be considered with group 3.
right.
And then if you win the lottery there, 90 days would be given. That is.
My lord, here, my lord, yes, my lord, your lordship, I may tell me that.
Mr. Hawk, this time I can't help.
My lord.
Normally I try to help you.
My lord,
Bad case.
my lord, so far that close, my lord, what your lordship was reading, my lord. To my little understanding, my lord, group 1 also included with this 90 days.
Yeah, wrong understanding. Try and fight it out in group 3. You see, there is a difference. As per section 44 of the Transfer Property Right Act, you duly have your right to transfer.
Yes, my lord.
There's no quarrel with that. But that right is one right. But the main problem is this. Tomorrow they set up that particular thing. And this person comes over and comes out there and says that, look here, no, nothing doing. I also want a part of it. How will they? See, this is not a short-term lease.
Yes, my lord. It is
a 19 years, 11 months.
Yes, my lord.
The
My
very
lord,
long lease.
my lord, the brother, my lord, of the lessor, my lord, he had already submitted no objection, my lord. And that is why, my lord, 1 bigha 4 less had been mutated, my lord. And
Where is the mutation of 1 bigger formally, sir? There's no mutation, obviously.
permission for lease.
Permission is different.
Permission is, yes,
Permission
my
is
lord.
different.
Yes, yes.
You can get many permissions. You have that. Hello, I think dismissed. I've heard you a long.
My lord,
Anything more to say? Otherwise, you will say this judge doesn't listen to us.
my lord, kindly come to please 131 for a moment, my lord.
Huh?
131, my lord.
131.
This is also,
Yes.
yes, this is a possession note, certificate, my lord. Issued by the circle officer, my lord.
Yes. So,
So he is possessing his portion of land, my lord.
So?
So ultimately, my lord,
you are an expert civil lawyer. Don't you know that possession of a co-owner is always the
Yes, yes.
possessor of one of the joint owners is always considered to be the possession of all co-owners? Isn't that the settled principle of law?
Yes, my lord. But at least, my lord, I'm paying, my lord.
Only thing
If the lordship allows, my lord, some time, my lord. So, my lord, the petitioner can mutate his own portion of land, my lord.
we should have thought about it earlier.
My lord, actually, my lord, there is probably a misconception of the, my lord, clause 4, my lord. That was a misconception, my lord. 4, my lord, that was, my lord. And moreover, my lord, since they what is the notion was taken, my lord, that since my lord, the lease was, my lord, granted, my lord, and after issuing the NOC, my lord, from the concerned, my lord, authority, my lord. Otherwise, my lord, the partition could have done, my lord. Nowadays, it is not so.
Pass the order. Dismissed.
My lord, can I have some chance, my lord, so the honorable petitioner to get mutated, my lord, the land, my lord.
That cannot be done, my lord. As per clause, my lord, land should
Yes,
be
yes.
available with the applicant
Yes, yes.
as on the date of application.
I have gone through.
And should have minimum lease of 19 years and 11 months as advertised by the respective oil company
Right.
from the date or after the date of advertisement, but not later than the date of application.
Yes.
Mr. Mr.
Yes, yes.
also understand that he'll get dismissed. He's trying his best. We should give credit to him. For that, I'm not imposing cost.
My lord.
Apply.
May Lordship.
Monday we'll get there.
May Lordship. May Lord.
Oh, again that case.
Yes, some ray of hope is there, my lord.
Your ray of hope cannot be there from Tinsukia. Ray of hope can happen here when you face the dismissal right here out here.
My lord, kindly have a look at the Constitutional Bench judgment.
Which one?
This 2001 judgment, which my lord has referred.
Bench.
Yes.
Constitution.
Yes.
Yes, my lord, this is a 5-bench judgment. Lordship has aware and referred also. Now, after the dissenting note of the Justice Sabharwal, the 3 judges also add 2 paragraphs, my lord. Paragraph 44 and 45. Now, 45 has given something to this case, my lord, if my lord has considered. Even if not mentioned in the WS, my lord, but if the facts and circumstances warrant such consideration, then at any stage, my lord. Paragraph 45.
Kindly come to paragraph 17.
So that's why I have gone through them. My lord, the Constitutional Bench has considered the Shambhunath Goel's case, and the Justice Sabharwal has dissenting. saying that the Sabrawal, this Sambhunath case is too technical. Now, thereafter, the three judges again add these two paragraphs, my lord. Wherein paragraph 45 saying that at any stage, if the facts and circumstances were in such consideration. Now, in my case, my lord, that facts and circumstances is absolutely is present, my lord. That kindly, lordship may kindly consider.
Here it says that the court has the power to call for any evidence at any stage of the proceedings if the facts and circumstances of the case demands the same to meet the ends of justice in a given. We read
Correct, my lord. Now,
when
kindly consider, my lord.
the management has to seek leave of the court in the written statement itself to lead additional evidence to support its action in the alternative and without prejudice to its right and consension, but this should not be understood as placing fetters on the powers of the court.
I understand, my lord. Now that's I understand. Now, lordship kindly
Section
consider
7 of the Industrial Tribunal, Industrial Disputes Act 7A says that a High Court judge can also be a presiding officer of the labor court.
my lord.
So let me go there and
No,
give
my
you
lord.
the permission.
Right.
Otherwise, not possible. Constitution bench judgment is very clear.
Now the Constitution bench, lordship kindly have a look at the last.
You try your luck there and file an application.
I filed an application, my lord.
That
I
was
have,
rejected.
no, that was under consideration.
Go fight it out there and say, finally consider.
Now, what happened, my lord? Why we are before this committee?
No. I can only pass an order that Mr. B. Dutta, the learned senior counsel, submit that the petitioner would be well advised to approach the learned labor court and insist on the said application, and thereupon, if so aggrieved, shall pursue such remedies as available under law. That is the only order I can pass. Nothing more.
My lord can only add that if the facts and circumstances of the case in hand, if such facts and circumstances warrant such consideration, the learned tribunal may consider. That's much I once meant.
Wouldn't that be a direction?
Not direction, my lord. It's only consideration of the facts and circumstances.
No observation.
No, I'm not asking for any observation.
Only that, Mr. Dutta. Otherwise, ask for a dismissal. The moment I dismiss it, you cannot raise that in a writ petition when you are going to file against the award so passed against you.
No, I cannot, I know.
But you can very well raise that issue.
Yes.
You see, the thing
Now,
is,
what happened? My lord, kindly hear me.
Mr. Dutta, in Sambhunath Goel or whatever it is, that in that case, one very interesting observation is being made that why you are required to file this.
Correct.
Although Justice Sabharwal says that no, taking into Cooper and Firestone, they should be permitted.
Yes.
And in Sambhunath Goel's, these aspects of in Cooper have not been looked into. But the Constitution bench, more particularly the Justice Santosh Hegde, says that on the basis of the stare decisis, we should not touch.
Yes.
And the reason or the rationale behind it appears to be on the basis of that if there is a delay in the proceedings by which they have not sought for and later on it delays the proceedings, then it would break the morale of the workman.
My lord, only thing is, my lord, may I kindly consider in Sambhunath Goel case, they come up after 14 years by that application.
14 years, 5 years, that's a Constitution bench judgment. I can't help it.
My lord, may.
One thing you fight, I can issue a notice only, no stay,
I'm not
direct the labor court to complete it within 6 months.
No, I'm not that. I'm
months
agree with this honorable court. I am agree with the honorable court. I am agree, my lord. My only thing is that the learned presiding officer has fixed the matter for
But
consideration.
Mr. Doctor, have you looked into my judgment? Where I
Yes.
distinguish this
Yes, a
judgment?
PK Rai judgment. I have a PK Rai has appeared. But
There I
that's a
distinguish it.
journalist case. Journalist case.
I distinguish this judgment of
Yes.
the Constitution bench, but
Yes.
in your case, I cannot.
Yes, yes. But would it be not?
And there, the court, in that case, when the records were called for, the court permitted it.
My lord, I understand. I'm gone through. After you referring, my lord. Now, I am only impressing upon that paragraph 45 last part. That the
That too, you can very well show it to the learned labor court.
that part, that observation, my lord.
No, I would not say anything. You are too good a lawyer to show it before the labor court, and the learned labor court would definitely hear Mr. Doctor on that. And kindly don't and ask the Guwahati High Court to remove the screening of this video so that the learned labor court does not listen to this.
I
have deliberated with you.
I leave it to this honorable court, my lord. I leave it to this honorable court.
Okay, heard Mr. B. Dutta, the learned senior counsel, assisted by Mr. S. Deka, the learned counsel appearing on behalf of the petition. The learned senior counsel submits that there is already a petition filed seeking the leave of the court to adduce evidence, he would not like to press the instant writ petition without prejudice to the application which have been already filed before the learned labor court. Taking into account the above, the instant writ petition stands closed on withdrawal, the withdrawal of the instant writ petition, however, shall not prejudice the petitioner in the application filed seeking the leave before the learned labor court.
Production list item 2 for motion.
Grateful, my lord.
Yes, what is it?
My lord, to make a very fair submission, although I have enclosed all these tender documents, etc., translated everything done, but since Monday is the opening day, why should I pray for a stay? Putting the question to myself. Rather, it would be quite prudent, if I may be wrong, to have a look what transpires on Monday. Maybe people do not bid, or maybe they bid quite few too many. If many are bidding, then mine may not be a purely academic exercise, but notice can be issued. But if, hypothetically, my lord, since I understand that.
Because of taking up the matter, you have taken up the breath of Mr. P. Sharma.
No. I'm making a very, I don't know.
Not scared that it's time
No.
I'll get a stay.
No. Things, tender should go on. What I am on is that, could it be, because my colleague had made the mention on Monday, this morning, I was not available there. I would have said it first, that Monday, if the tenders are open, and if the many bids are found, okay, they are okay with it, then one way. If other bids are falling less than the minimum revenue, then it might be a different call altogether.
Then no problem at all. Can you give below the rate?
No, that's what I'm saying. Then
so your repetition gets allowed without even
absolutely.
Agree.
That I don't think. Well, I may be wrong, but I thought it that way.
List the matter on Wednesday.
Obliged.
You have taken the breath of Mr.
No.
Sharma.
I told him that.
Item 18, implement of party.
Whom do you want to make party?
My lord, the magistrate, my lord. District magistrate, my lord.
District magistrate. You want whom to be made party? District magistrate. Oh, that matter. What happened, Mr. Sarvi?
My lord, the district magistrate has passed the order, but the executive magistrate is not giving time to take over the physical position of the property.
How is it possible when there are Supreme Court judgments?
DM has already passed on, but the executive magistrate is not providing time.
So now you will make the executive magistrate a party.
Yes, my lord.
Anyway, let us make the DM a party first.
My lord.
There is an application filed by the petitioner seeking leave to implead the District Magistrate Kamrup Metro as a party to the accompanying writ petition, taking into account that the District Magistrate Kamrup Metro is the authority who is required to act in terms with Section 14 of the Surface Act.
Yes, ma'am.
In a full naam to likhi diyo. Taking into account, this court further takes note of that the respondents or the opposite party banks, that is the opposite party number 1, 2, and 3, have already initiated action. However, the allegation is that the respondent opposite party number 4 have not provided the necessary, have not done the needful in terms with Section 14 of the said Act. Taking into account the above, this court therefore impledes the district magistrate, the opposite party number 4 herein, as the respondent number 4 to the accompanying petition. I stand a conduct of CIS to the file within by Tuesday. You'll file it on CIS update. I stand you see file a fresh memo of parties before the registry within Tuesday.
Yes.
And on the basis thereof, now main petition. Miss Udas accepts notice on behalf of the newly impleaded respondent number 4. Miss Udas to list this matter again on 15th of October 2025. In the meantime, Ms. Udas, the learned additional senior government advocate, shall apprise this court as to why no action has been taken in pursuant to the approach made by the respondent numbers 1, 2, and 3 before the respondent number 4 in terms with Section 14 of the Hague Act.
Extra copies, man.
Extra copies.
Man.
For
Okay,
admission at
issue notice-
24.
Issue notice making it returnable. Issue notice upon the respondent number 4 making it returnable on 15.
Matlab, GA Assam may be shown in the cause list, my lord.
The name of Ms. CSR Udas is shown in the courts.
My lord, deeply obliged.
Okay.
None appears on behalf of the petitioner on call. It appears that the petitioner have not appeared before this court on the earlier occasion. Yes.
Lordship, the matter has become infructuous, Lordship.
Okay. Ms. So-and-so appearing on behalf of the petitioner submits that the writ petition has become infructuous in view of the fact that the period of settlement is already over. Taking into account the above, this is PNRD. Okay. Taking into account the above, the writ petition stands closed on withdrawal as it has become infructuous.
25.
As if any stands. Yes, what is this?
Before Lordship, my lord, he is a settlement holder, my lord. My lord, he has, my lord, not, my lord, got possession of 6 numbers of the part of the fishery, my lord. And encouragers, there is a report, my lord. Also, your lordship go to it, page 63, my lord. This page 63, my lord.
So what am I going to do?
My lord, they
Tell
can.
me, what can this court do?
My lord, direct-
You say that entire fishery has not been handed over.
My lord.
He says that you entered into an agreement after being satisfied, after the possession being handed over. Now, if it has not been handed over, what can we do? If only we appoint a commission to look into it as to whether the entire fishery has been handed over.
My lord, is not, the report says that, my lord. The Deputy Commissioner, Managing Director requested to the Deputy Commissioner inquire the matter. And the circular district, the circle officer appointed for inquiry and report by the page 65, my lord. Page 65, annexure 18, my lord. With reference to the subject cited above, I have the honor to inform you that I have inquired above mentioned subject of following findings were made during inquiry. Lease has acquired possession of Mahbil so-and-so portion Borlahi Sambora Min Mahal and has informed to the undersigned office in writing regarding handover possession of Kila Kili part under Bolahi Sambora Min Mahal. A court case over so-and-so was initiated in Honorable Guwahati High Court and matter is pending before the Honorable High Court Guwahati. Regarding handover the position of Beltoli part under Bolahi Sampara Bill, a court case number so-and-so is initiated Honorable Guwahati High Court and matter is pending before the Honorable Guwahati High Court. In spite of servicing
What is your
notice,
prayer?
my prayer is that my Lord directed.
Remission.
No, first my Lord, I am praying before your Lordship to direct the respondent to free and set Min Mahal from the illegal possession of an enforcer in respect of
They can't do anything in view of the court cases.
No, my lord, that is my lord. I have my lord inquired is the missing autonomous council given the settlement, but that is set aside by the Honorable High Court. Missing autonomous council has no power because of this is the he also know my lord. Missing autonomous no right, my lord. And my lord, now all localities enforcing the Mahal, all locality, my lord, missing community, they entered my lord and not to go anybody, my lord. So they're doing fishing the fishery. I have some loss, my lord, because of that. Due to my lord, agreement is concerned, my lord. At that time of settlement, they made an agreement. Possession thereafter, and they did not possession just a minute. They did not give the possession 2 months later. They give the 2 months later and came before the Honorable Court. Honorable Court directed there is a order, my lord. But thereafter, I am going to taking position that portion of the fishery they did not give they doing that, my lord, illegally, my lord, fishing, my lord. So my prayer is that they will
You are the
directly,
first timer.
my lord.
Are you a first timer taking the possession?
Yes, first time.
Earlier you never did business. of
I
fishery.
am not.
First time. First time. First time.
I don't. No, you
You've never had the experience.
Not experience, we cannot give lordship.
If he has not, isn't this the 60%?
No, lordship,
Eh, So first timers you give without experience.
fishing experience is needed, lord. Fishing experience is needed.
So he must be knowing that here missing autonomous council and everybody knows about all this.
He must be knowing, lordship. Actually, there is an agreement. When agreement is signed, lordship, I can produce a record. They have signed that they will not claim anything for this. They will not seek remission that we have not got the possession. We have not some enforcement is that and specific clause is there. And number one,
Hello. What is there to do? There's no urgency.
File
You have not filed your affidavit.
No, lordship. Well, I will produce
Why?
record. I will produce record, lordship.
No, you need to file your affidavit whether as regards more particularly in view of this document.
Page 56, my lord.
Ah,
I will find. Kindly give me some document.
you cannot, and we impose a cost of 10,000 upon you. 2024 you have not filed your salary. Okay, 10,000.
No, lordship, they are for task for lordship. Past
Huh?
lordship. Past I usually file lordship. This is past.
Today, FDC is saved because of one matter. There was nothing, no notice has been issued.
Cost will be cost.
So therefore, no problem.
Lordship,
We impose a cost upon you.
no, lordship, I will file the affidavit. I'll allow it record, lordship.
It is seen that in the instant case, notice was issued in the year 2023. On various occasions, the respondent AFDC have sought for time.
Lordship,
The respondent AFDC sought for time on 2/8/2024. But even after a year have passed, the affidavit has not been filed. Considering the above, this court fixes this matter on 17th of November 2025. It is observed that if the affidavit is not filed by the AFDC on or before 7th of November 2025, the affidavit of the respondent AFDC shall not be accepted, and the instant with petition thereupon shall be taken up for disposal on the basis of the materials already available on record. no defense.
I will notice the record also on that.
Records, first file affidavit, then records. Why will you look into records?
Not much.
Please your lordship. Petitioners are scheduled right forest dwellers residing in Borlandpur District Council Reserve Forest in Karbi Anglong District, lordship, belonging to Chakma community.
Huh?
Belonging to Chakma community.
Chakma, you are not scheduled right
Chakma is scheduled right, lordship.
in Assam.
In Assam. I have enclosed the scheduled caste certificate also.
Then what happened? Last time one matter came up like this out there.
This particular there areas impediments are there regarding the implementation act of the industry schedule area. My lord, under Article 243M, my lord, Panchayat is not applicable in the 6 schedule area. Under Article 243M. Lordship, look into Article 243M, my lord. Article 243M.
Constitution. Whether this matter will come up before this bench? Bench.
It's the, my lord, right of the, my lord, civil tribes in under the Forest Dwellers Act, my lord. They are claiming the rights.
That I understand, but land matters do this court takes.
So, my lord, if lordship, look into my lord.
Normally it's the bench.
43M, my lord. Nothing in this part shall apply to the civil areas referred in the tribal areas referred in the clause 2 of Article 244(2). Article 244(2) reflects, my lord, about the applicability of the 6 schedule area in the state of Assam, my lord. So, my lord, this part is not applicable, my lord. The Panchayat is. And my lord, if your lordship look into the civil types order, other traditional forest dwellers recognition of Act 2006, my lord, and there is a, my lord, forest right committee is required to be constituted by the Panchayat, my lord. So if there is no Panchayat, my lord, the forest right committee cannot be constituted, my lord, in that particular area.
Bad case. He has good case. You have a good case.
Lordship, look into it, my lord. Lordship, look
They
into the
are,
rule
if
3.
they are scheduled tribe, if you are recognizing them, you
My
have,
lord, there is another point
unless
is
you
there, my
say
lord.
that the
My lord,
Forest Dwellers Act does not apply to Karbi Anglong, you say that.
my lord.
It doesn't apply.
My lord, no, my lord, the applicability of the act, my lord, as provided in the rules, my lord, it cannot be applicable in that way, my lord. Lordship, look into, my lord, rule 3, my lord, of the Scheduled Tribes Order, my lord.
Order, what order?
Yeah, Scheduled Tribes Rules 2007, my lord.
Where is it?
Rule 3.
Where is that?
This book.
Yes.
Lordship, look into Rule 3, my lord. Gram Sabha.
Prevention of it. Forest dwellers.
Forest Dwellers Act. Scheduled Tribes, Other Traditional Forest Dwellers Act 2006. That another point is that, my lord, Citizenship Act is not applicable in the, my lord, six schedule area. And the persons, Sakma communities who comes from the Myanmar, from the subsequently, where they cannot claim citizenship in the six schedule area, my lord. Those Sakma people who are living prior to 1953, only they are recognized as scheduled tribes, my lord. These points are also there, my lord.
There is no affidavit time.
My lord, regarding, my lord, there difficulties are there, my lord, so I want to point it out, my lord. Rule 3, my lord. Scheduled Tribes Rules 2007.
Yes.
Gram Sabha. The Gram Sabha shall be convened by the Gram Panchayat. And its first meeting it shall elect from amongst the members a committee not less than 10. My lord, so the Gram Sabha is required to be convened by the Gram Panchayat, my lord. If there is no Panchayat in the scheduled area, my lord, who will convene the meeting, my lord? That is required to be clarified by the central government. And my lord, they have the power to issue notification, my lord. Until and unless central government notifies, my lord, and lordship, how the committee is constituted, my lord. And that this rule 7, my lord, district level committee who will finalize the forest dwellers' right. District level committee is constituted by the district collector or deputy commissioner, divisional forest officer, 3 members of the district panchayat. So if there is no committee, my lord, it cannot be, my lord, finalize who have the right of the forest right, my lord. Forest
No, no, forest right is already recognized, but the fact that you give them patas.
My lord, there is no issuance of pata, there is no provisions. Only they have the right, my lord.
No, they have the patas, the right.
My lord.
See no, Mr. Kindly see section 3.
My lord.
What is the right?
My lord. Section
3A, right to hold and live in the forest land
land.
under the individual or common occupation for inhabitation
Or for self-cultivation for livelihood by member
You
or
see,
members.
rights in over disputed lands, right to conversion of pattas, G,
My
or
lord.
conversion of pattas or leases or grants issued by the local authority or a state government on the forest to title. These are all there. Right of settlement, conversion of all forest villages.
They are, my lord, they are occupying, my lord, forest land. They are seeking the rights over the forest land, my lord.
That
in
is
this
what?
particular case.
They have a right.
My lord, but if they have the potta, my lord, then it can all be converted to a potta. They have no potta, my lord.
They also have a right to claim settlement.
My lord, right to settlement. But settlement rights can be given by the district level committee.
District level committee, how do they have the power over the forest?
My lord, it is the, my lord, provision is there, my lord. It is a rule, my lord. Rule is there. Lordship will look into the rule 3, my lord, rule 4, my lord. Function of the Gram Sabha. So first impediment is that.
Mr. Dute, why should we go into the rules first? First, see the act.
My lord, my lord.
The act empowers them and recognizes them. And act gives them such powers as per section 4, even in notwithstanding the provisions of the Forest Conservation Act.
My lord.
They have power.
My lord, they have
Being
the
scheduled tribe.
My lord.
Other forest dwellers is 75 years.
Yes, my lord. My
But for them it is different.
My lord.
So therefore the question is, they have a right.
But they have a right, but the recognition of the right can be given by the particular
No,
committee, my lord.
therefore the question is, if their recognition is not in a position, it's not being done so on account of the rules not being implemented or cannot be implemented,
My lord.
and it can be done only at the behest of the central government
My lord.
who have made the rules.
My lord.
The central government is made a party.
My lord. So that is my submission.
And the central government has not made a file.
So that is my submission only, my lord, today. So the central government is the necessary party, my lord, so that it can be, my lord.
You have not made the central government a party.
Not a
Not a
party.
party, my lord.
Not a party, Lord.
You do one thing, sir, make the central government a party.
My
Needs
humble
of target
submission is
investment.
that, my humble submission is that, Lordship, there is already a district level committee. Initially, they had not considered our claims on the ground that there was no district level committee that we obtained through RTI reply. The latest RTI reply, 25/10/22, page 67, para 4.
Lordship can look into annexes 7, page 60, that the district level committee constituted by the deputy.
Yes, my learned senior initially submitted that there was no district level committee.
There
But
is no record available in the office
Para
of
4.
the date of petition number so and so.
Para 4.
Processor be at the time of constitution of the district level committee under the schedule type in accordance with the government instruction was not held due to nomination of council officials being land matters on so and so. During exercise of the RTI application under so and so, letter was sent to the principal secretary requesting to nominate members for formation of the district level committee. Accordingly, on receipt of names of nominated members, committee has already been formed. But the sitting of the committee is yet to take place. No, but the district level has been formed with 3 nominated members of KAC. Letter A. And what is the role of the district level committee?
Now, detailed procedure is entirely laid down in the Act itself. Initially, Lordship, Section 6 provides that application claims are to be made to the Gram Sabha. Lordship will kindly have a look at the Act. Claims are to be made to the Gram Sabha, Section 6. Section 6. authorities to vest forest rights in forest dwelling scheduled tribes and other traditional forest dwellers and procedure thereof. The Gram Sabha shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights, or both, that may be given to the forest dwelling scheduled tribes and other traditional forest dwellers within the local limits of its jurisdiction under this act by receiving claims, consolidating and verifying them, and preparing a map delineating the area of each recommended claim in such manner as may be prescribed for exercise of such rights, and the Gram Sabha shall then pass a resolution to that effect and thereafter forward a copy of the same to the subdivisional level committee. Now, subpara 6, Lordship will see. State government shall constitute a subdivisional level committee to examine the resolution passed by the Gram Sabha and prepare the record of forest rights and forward it through the subdivisional officer to the district level committee. Here comes the district level committee for a final decision. Then Lordship will have a look at para 6, clause 5. The state government shall constitute a district level committee to consider and finally approve the record of forest rights prepared by the subdivisional level committee. Then 6, the decision of district level committee on the record of forest rights shall be final and binding. And the further detailed procedure is laid down in the rules. How the verification and all is to be done. Now, my prayer is not that, Lordship, I should be granted the forest rights. I am only praying that they should follow the procedure of recognition and vesting of forest rights as enshrined under the Act of 2006, read with the rules. I am also relying on a decision, Lordship will find at page 69. This case also pertains to Karbi Anglong district only, Lordship. And here, Lordship, there was also a notice of eviction, which is not the case scenario in my case. There was a notice of eviction also involved in this case. Here, Lordship will kindly have a look at page 85. 85, para number 26 is about that eviction notice. And para 27 is regarding the procedure to be done. I'm reading both the paragraph, Lordship. Para 26. In view of the above, this writ petition is disposed of by directing respondent authorities to follow the procedure of giving opportunity of hearing to the petitioner as regards their encroachment in the forest lands as indicated in the notice dated so and so, and thereupon pass a reasoned order as regards their eviction if circumstances require so. This is not my case. Para 27. On the other hand, if the petitioner makes a claim for forest rights under Act of 2006, they be subjected to the procedure of recognition of forest rights under the Act of 2006 by following the procedure prescribed in the rules of 2007 as indicated above. The entire requirement be done and brought to its logical end within a period of 3 months from the date. I'm only praying that the procedure be followed and completed within a time frame. And regarding our entitlement, etc., will be decided by the district level committee. It is only because the district level committee is not sitting, our claims have remained unconsidered till date.
Lordship may look into the rule 7, my lord, how the district level committee is constituted. Is required to be constituted.
Since
But Mr. Counsel, see, with due respect to the coordinate bench, the coordinate bench have directed the respondent authority to follow the procedure of giving an opportunity of hearing to the petitioners as regards the encroachment in forest land as indicated in the notice and thereupon pass a written order as regards eviction. That is one. Now, if upon following the procedure of forest right is recognized, such right be granted to the claimant in the manner provided in the rules. Now, the problem which is arising out here is the rules insofar as Karbi Anglong is concerned is said to be unimplementable. That is the problem. Getting an order, I can very well pass an order, but how do you implement it? There's no quarrel, Mr. Counsel, that I am in support of you, that you are entitled to, taking into account that you are a scheduled tribe and you are entitled as per the Scheduled Tribe Act. You are entitled. But the problem arises is unless the procedure for the purpose of compliance, it is not being done. It can be done through the central government.
The Lordship will for a moment look at page 68, the notification by which the district level committee was constituted. It was constituted on 10 April 2020.
District level committee is actually an appellate committee. Why are you not understanding that? First, it will go to the Gram Sabha.
Gram Sabha.
Then it will go to the subdivisional committee. Then it will, the appeal lies to district level committee, and the district level committee's decision is final and binding. But you want this court to direct that you directly be take up by the district level court. Isn't it? Would that be proper? Tell me. Think about it during the vacation. In the meantime, I think I would suggest you to make the central government a partner for better effectivity. Don't you think so?
Yes.
Then I can very well direct why you are not doing it.
There is no Gram Sabha.
How it will be implemented, because these are their rules. So then they may come up with some notification and thereby it may help you. It will be a larger interest point.
Yes.
Isn't it? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an application to impede the central government as a party to the instant proceedings, taking into account that the central government is the nodal Minister of Private Affairs. Minister of Private Affairs. To make the central government as a party, taking into account that in terms of section 11, the Ministry of Central Government dealing with tribal affairs is the nodal agency. Section 11 of the Econ Act. SC, ST and other foreign. List this matter upon such application is filed. And Mr. Chukde, I think you should file your affidavit also.
My lord, only for those, my lord, that impediment, we could not do anything, my lord, to comply the order regarding the eviction.
No,
my
because
lord,
there is already a direction passed by this court.
my lord.
Why are you not filing your affidavit?
My lord,
In the meantime, affidavit be also being filed by the Karbi Anglong Autonomous Council without fail.
Deeply obliged.
Yesterday we have filed our affidavit and reply, Lordship.
You want to file reply?
No, already filed yesterday, Lordship.
It has not come on record.
Yes, Lordship. Not record, Lordship.
You have filed reply.
We have already filed affidavit in reply, Lordship, which was filed by the respondent number 4, Lordship. Yesterday we have filed, Lordship.
It has been submitted by the learned counsel for the petitioner. What is the matter about?
Lordship, matter is pertaining to the non-eligible of performance security money, Lordship. Lordship, we have completed one construction work, Lordship, as per work order, Lordship.
Yes, what is this? 1,60,000.
Yes, Lordship.
Why haven't you released it?
Lordship, some defects were there, Lordship. So some defects were there regarding the completion of the work, Lordship. They did not fulfill the terms and condition of
It
the
has
work.
been
order.
submitted by the learned counsel for the petitioner that an affidavit in reply has been filed. Taking into account that the pleadings are complete, list this matter on 27th of October 2025 for final disposal at the admission stage.
29.
My lord, this
Same person.
my lord, payment of my lord contractual.
Your same person keeps on filing.
Yes, my lord.
He is so affectionate to you, Mr. Counsel, that even after withdrawing the requisition also, he continues.
With that amount, process is going on, some time may be required. So that's not difficult.
Assam Seed Corporation has admitted, and my learned friend also has some instructions today. On the last occasion, my lord was pleased to give them the direction to bring the current status, my lord, on 22/8/2025.
How much amount?
My lord, total amount which was used to the petitioner was around 51 lakhs and some odd, my lord. 23 lakhs, 51,500, my lord.
23 lakhs.
51,500, my lord.
X. 6 months.
I'm a disposal. I'm a. Helio blade.
এখন put কৰিব দি মই এটা order আছে agriculture department put কৰিব মানে ভৰসা কৰিব
May please allot it.
yes
Non-payment of an amount of rupees 7,06,000.
PWD
PWD.
চলো
Admitted amount, you know.
discuss কৰিব Kamsarali none appears who appears for PWD none no PWD council
31.
today who appeared in the during the day any PWD council appeared today
I have seen Mr. B. Gogol.
okay we go নাম দিলো
Oblige.
এইটো আমাৰ within এয়া কৰি Kamsarali yes what is this
In this case, my lord, I have filed affidavit yesterday, my lord, but admitted amount is, my lord,
affidavit you have filed
my lord, yesterday, my lord.
what do you say
Here, my lord, our admitted amount is, my lord, though 19,23,000 as claimed by the petitioner is correct, but we have in the meantime, we have paid, my lord, and now remain, my lord, 15,76,314.
affidavit copy to
My office
এইটো
copy.
এনেকে লিখি ইমান খিনি দি দিম
Paragraph 8, my lord, it is mentioned.
put কৰি দিব this is an extra copy for me
Yes, my lord, I have made it.
এখন affidavit মতে দি
Paragraph 8, we have mentioned.
paragraph itu copy yeah di paragraph 8 itu suppose we put Mr. A. Khonikor's name up there
32.
Hey, please allot.
yes Mr. D.
My lord, I may be allowed 1 week time to file affidavit and reply, my lord.
okay not 1 week I give you more okay Mr. PC Day 6 for an accommodation to file the affidavit in reply to the affidavit filed by the respondents on 22/7/2025. Okay, list this matter. No, that list the matter only upon the affidavit in reply being filed.
33.
I'm agreeing for respondent number, I need 1 week time to file our application.
What? On behalf of Mr. P. Sharma, Learned Standing Council, AFPC, for the respondent numbers 1, 2, and 3. Mr. So-and-so, since the NIT is in vernacular. What? Same is brought on record.
I prepared it, but I
P.K.
could not file it.
Chaudhary, Roy Chaudhary, yeah. What are you challenging, Mr. Roy Chaudhary?
My lord, we
I
are challenging the order by
translated it.
which our,
I have translated it, but I could not file it. That's it. This
Good. Yes, what have you challenged?
my lord, by the way where my technical bid and the financial bid where I was allowed, it was cancelled and ultimately respondent number 8 was given that settlement of the fishery. My lord. By,
Who is running?
my lord, they are, I'm not running, my lord, they have joined, my lord. Because they have taken over, my lord, they have been allotted that fishery.
Yes,
Respond-
lordship.
Let them run till Bihu. Then we.
My lord, because my lord, your lordship, my whole count is this, they have not provided me the opportunity. Because the only allegation, what I found from
For
the,
how many years it has been given?
for 7 years, from 24 to 7 years.
You can wait because, yeah, 7 years, let them have the Bihu. Take you to some.
My lord, can it be just after, my lord, your lordship can understand, I was technically allowed, I was the highest bidder, financially I was allowed, then by some,
But they have not filed their reply.
my lord,
You have got the vernacular.
I prepared it. This is the particular one.
This is.
translated one.
You have not filed your affidavit.
No, lordship.
I'm going to file it. Could not.
When?
The day I was supposed to write.
Have you filed your affidavit?
No, lordship, I need 1 week
Okay,
time to
you will
file.
file your affidavit when we state.
No, lordship.
Please let us state, then you wait,
Lordship,
let the fish rot somewhere.
This is in the vernacular.
Yes.
Vernacular translated one. Last time it was ordered also.
Let us pass a stay order. As you have not filed the affidavit.
No, Lordship, today the deponent due to illness, he could not come to notarize, Lordship. Lordship, Monday, I will file Monday,
No,
Lordship.
no. This can't happen. So delayed.
No, Lordship, as
They
a
have
last
done
chance,
some
Lordship.
illegalities, right, left and center. Written arguments given, then also not considered.
As a last chance, Lordship, I will file on Monday, Lordship.
Huh? Monday.
Yes,
APC,
Lordship.
when you are filing Monday,
Yes, Lordship. Monday, I will file.
File Monday.
Monday file it, otherwise we dismiss.
Monday I will file it.
Pass
Take
us-
it on Wednesday. Lord.
We'll take it up on Wednesday. Wednesday, 2000 kita ase.
Matter is very simple, Lord. Don't.
Your simple matter is always very difficult. You always
big,
come up
Lordship.
later on with a complicated, and you have another person who makes further complicated. So now we have a complicated square councils. Now the resultant effect would be so difficult for this court. Your simple is very difficult. Anyway, Mr. P. Sharma submits that the affidavit in opposition would be filed on Monday, that is by 22nd of September 2025. Ms. So-and-so, the learned counsel who appears for a private respondent, also submits that the affidavit
Proposition.
in opposition will be also filed on 22nd of September to list this matter on 25th of September at 2 p.m. to stop. In the meantime, the petitioner would be at liberty to stop. In the meantime, the petitioner would be at liberty to file their reply. Full stop. This court, taking into account that there is no interim order passed, would make an attempt to dispose of the petition on the day.
34.
We have filed the affidavit yesterday, Malat. However, regarding service upon the petitioner, Malat copy, there is some confusion. Anyway, I'll
Pradhan-Mantri Awas Yojana,
today, Malat, I'll serve him.
taking the respondent a right to bring on record the stand by filing the appeal of non-human. Are the petitioner entitled or not?
Malat, actually, the central government will say, Malat, because of
Yes.
The Secretary to the Government of India informed me that the implementing agency is the state authorities. And
with the
the whether
So
they are
you-
entitled or not, it
You are
will be
just transferring the buck from here to here. She is doing to you.
no, my lord, guideline is there, my lord, the central government
So
guidelines.
the
and-
simple question is whether the petitioners are entitled in terms of the Pradhan-Mantri Awas Yojana. Isn't it?
Yes.
Affidavit filed? No affidavit filed.
Malat, yesterday I have filed, Malat,
You have filed.
by respondent number 5, Malat.
You have not filed.
Not parliament.
You are not going to file.
My lord, I will file it, my lord. I shall file it, my
So you accept what is been stated in the writ.
because
It is your submission that you accept it, what is stated in the affidavit. So we'll only see as to whether the stand taken by the state is right or wrong. Okay.
Where?
my lord, time may be granted, my lord.
How
Time,
much time?
3 weeks time, my lord. 3 weeks time.
We fix a date. Affidavit has to be filed. There's no question out there that no. Mr. So-and-so appearing on behalf of the central government commits that the affidavit of the central government will be filed on or before 27th of October 2025. To list this matter
27th of
again on 7th of November 2024. Liberty given to the petitioner to file reply. The affidavit would be at liberty to file the reply if it.
My lord will excuse me for not being able to make any submission. I'm feeling a choke and I'm sure my friends in the bar are equally. My lord is not aware. We have lost a state treasure a while back.
Oh,
Jubin Garg is no more.
I see. Okay.
Item 35 to 38.
Wait, please.
New weekly.
Yes, my lord. I'm appearing on,
What is this?
my lord, I'm appearing on, item number 38.
Ah.
It was in the motion and, my lord. And, there's
Move
a
on to 820.
weekly market. I'm Panchayat, my lord. And there's,
You are the Panchayat department?
no, Panchayat, my lord. We are the Joleshwar Anshalik Panchayat. I'm appearing on behalf of the Panchayat. There are cattle markets. One is, we are running because we have taken a private rate on lease.
There are eyes also. For what?
My lord?
There are stay.
Yes, stay on his rate petition, on her rate petition. Then, my lord, what has happened, my lord?
Who has filed the IA?
IA filed by, IA filed. It's her.
We have filed.
Find out.
I have filed by us.
WPC 237, item number 36 was filed first. Item 36.
This matter.
my-
Yeah, wait, now I get. Mr. Chaudhary, for whom you are appearing?
I am appearing in this WPC 237 of 2025 for the two petitioner. Actually, I am a private cattle market, my lord. There is no scope of any Anshalik Pansar or somebody to poke. My lord, there was an order of this honorable court whereby the power has already been expressed in this case. In this very litigation.
No, but.
The matter is very simple.
No,
my lord.
the
I am
private
running-
cattle market or whatever it may be.
Yes.
In view of the newly amended 107.
Yes. Yes.
The town panchayat, the government, everybody has to give an approval.
The regulatory power. No, there's no difficulty. No, that we are paying revenue. The revenue is going to
Without the
the.
approval, how can you run it?
No, where is the requirement of approval?
See, section 107.
No, my lord, if before that, if your lordship should kindly come to one order of this honorable.
No. This is section
No, after amendment, that order.
107.
Yes.
I got so. Oh.
No, it says, my lord, without prior approval of the concerned panchayat authorities and the government. The panchayat shall impose such fee, they have imposed fee, we are paying.
No.
It is not their case that we have not got approval, therefore we are running. That is not their case.
Yes.
Yes.
What does our High Court say?
Yes. My lord will kindly come to page number 54 in my writ petition.
Which writ petition is yours?
My lord, 237 of 2025.
237. Okay. Yes.
Please, 53. My lord, the order is a long order. Please come to page 53, my lord. I'll read from para 6 at page 53.
These are orders passed in 2022.
Yes, in this very proceeding, my lord.
But this amendment happened in 2023.
No, I'll come to that, my lord. Kindly see this order. This order eventually decides the fate of the case, in my humble submission. To substantiate the stand, Dr. A. Sarab, Lanet Senior Counsel for the applicant refers to paragraph 18 of the judgment of this court in Rupam Talukdar, following which interim order was passed, to indicate that second paragraph 18 clearly provides that although a person would be entitled to carry on business of conducting cattle market on his private land, but such market would still remain subject to requirement of any kind of permission or license to be obtained for running such a market from the authorities of the state. As in paragraph 18 of the judgment in Rupam Talukdar, it had already been clarified that although a person would be at liberty to operate a cattle market over his private land, but such operation would be subject to any other law. Accordingly, interim order dated 7/2/2020 in WPC numbers also would also have to be understood that operation of the cattle market by writ petitioner would be subject to requirement of the Assam Cattle Preservation Act 2021. Now, precisely at page 46, under the Cattle Preservation Act, permission has been given.
By
the Deputy Commissioner. The under the Act, my lord, designated authority is the deputy commissioner.
Now, where is the permission being given?
Yes.
Allowed to operate within the area under the jurisdiction with the prior approval of the concerned panchayat authorities and the government.
Yes, my lord. And my lord, for that, if your lordship would kindly come to first that page 46, my lord. Page 46.
Yes.
As notified by the government of Assam by notification dated 25/7/22 and in exercise of the power conferred by section 10(1) and 10(2) of the Assam Cattle Preservation Act 2021. And as
The deputy
prescribed by-
commissioner,
Deputy
not by the government,
Deputy Commissioner.
not by the government,
Ah,
not by the government
Yes.
or even by the panchayat.
Yes.
Where there are no objection from their permission.
No, my lord, we are paying revenue.
You cannot pay revenue out there.
No,
This
no.
is what I'm saying.
No, my lord, whose case is it that there is no approval of the authority? Whose case is it?
I'm-
And nobody has raised that issue, my lord.
No, if you are one.
No, my lord, there is a litigation is going on.
You cannot, on the basis of a 2002 or 22 order, have any relevance. Because here, this is the amendment. Earlier, there was no amendment. Earlier, 107 said something else.
Yes.
Earlier said that the power of settlement of private heart so and so under the jurisdiction of the Gaon Panchayat.
No
shall be
private
vested in the
heart
standing committee.
fisheries shall be allowed to
Now-
operate within the area of Gram Panchayat without prior approval of the concerned Panchayat authorities and government.
Now, Mr. Chaudhary, you'll see, these 107, which was earlier there, was set aside by the division bench. So 107 was no longer in the books.
Now this is the positive.
Now it is being inserted that you require the prior approval of the concerned panchayat authorities and the government. Anyways, that is, you are for the respondent of this.
No, I am for the petitioner in one case, respondent in the other case.
Now, what is the issue problem?
No,
Because
issue-
you see,
no,
why,
now-
how the matter came up before this court is this. He filed a, you know, yes, you have filed a contempt, or he has filed a contempt. He has filed a contempt that there is a continued violation of an order being passed.
Yes.
I normally don't issue notice in a contempt, more particularly, it is purely a private dispute between
two contesting parties.
Why should this court look into all these things now? But he says that, so I asked Mr. K. Gogoi to obtain instruction from the deputy commissioner as to whether the cattle market is running in spite of the stay order.
We are still running, Miller.
So what happens?
They are running. They are running.
On Friday.
There are.
I'll just
on
clarify.
particular, but the dispute is regarding on which date. It's Wednesday and Friday. That is the dispute.
I just.
No, you kindly see the contempt order.
Yes.
I'm saying about this contempt case to 394. 394, this is the basis of the entire contempt. That is in past 3389/2025. Madam Goel's case.
Order to court. Did he approval?
Kindly see this order. Kindly see paragraph 16 of the order passed on.
My lord, if the issue is approval, then my lord, matter can be sent to the government. Government will consider it. And because Panchayat thing is already there, this honorable court has already recorded that.
Which one?
Yes, my lord. If your lordship would kindly have this WPC order 4139 of 2024, that is page in the other petition, it is there.
No, Mr. Chaudhary,
Yes,
first,
my lord.
can you come to 3389?
My lord, order, my lord.
No, 3389.
Yes, yes. I'm coming in fact to that one.
First, in this case, there is an order passed by
18.3.
18/6/2025.
Facebook one.
Yep, nice. It is third.
Have you got that order?
No, my lord. I'm sorry, my lord. What is the date of the order?
No. It is an order passed in WPC number 3389/2025.
Okay, 3389 order to consider.
I'm on a straight getting up.
One second, my lord, I'm getting.
You have filed a contempt, na? Have a contempt petition? Give it to him. Mr. Choudhury, can you do it? Finally come to page 12.
Yes,
A.
yes, new weekly.
Okay, now you appear for whom?
I appear for five.
Five. Gornagar, this one.
Gornagar, Damri Bhasa, Bridge Tiniali, Posupot, represented by secretary.
You appear for 5.
Yes.
And new weekly heart of Basmura and others is by them.
Yes.
Okay. Now kindly come to page number 18.
Yes, my lord.
In the interim,
This court
finds that there is a prima facie case made out by the petitioners for staying the impugn order dated so and so issued by the district commissioner Gwalpara. Inasmuch as running of a market, private or otherwise, is within the competence of the state government, which has been decided by the principal secretary to the government of so and so department. Accordingly, the state order is state.
Yes, that order is state.
Now, which is this order of 35 is page 17.
Yes.
Of that. In pursuance to so and so, the animal laws should be here. And I think this is the order which you are referring to know.
Yes, we have filed IA for vacation of that order, my lord.
Hereby accorded.
And 35 order is at page 183, my lord, which they have challenged.
So this order allowing you.
Yes, by the deputy commissioner.
To open.
Yes, on Friday.
On Friday has been stayed.
Stay. There is a stay now.
There is a stay. Now,
we have filed an IA for vacating this order which your lordship has read.
Okay. Now that matter is going on.
Yes.
Okay. Now, is there any violation to this?
No, there's none.
Their allegation is they
Yes,
are completely and
we have been prevented from operation.
so therefore, I asked the deputy commissioner, yes, any information?
No, my lord have posted the matter after Puja vacation. They lords. Even the copy was.
That is our grievance. That's why we are before lordships with the IE. Nobody has violated that order, my lord. And my lord,
That is
I
why
can
I've
my lord, what
got
is
the
the
other
locus of the private party, my lord? They are not a settlement holder of the.
After passing of the order, my lord, I informed the DC that then DC now he has been transferred, but that has been stayed. Yeah. But they are operating, madam. Petitioners are operating
On Friday.
No.
on Friday.
Who is running the cattle market there?
They, my lord.
They are
You are running.
My lord, I'll tell you, my lord, you have the facts has been placed differently, my lord. What is the actual, what has happened? There are two markets, my lord. They have been allowed to run the cattle market on either on Monday or Wednesday. They are running. And so far we are concerned, my lord, that is on Friday. The question is not like that. They are also running. That is on Monday and Wednesday. Now, what are the two different dates? My lord, your lordship will kindly.
Bone of contention is
It's a
Friday.
different. I just place this, my lord. They have suppressed all these material facts, my lord, before your lordship to get the orders, my lord. Suppressing all these things, my lord. Your lordship will kindly see my application. That is annexure 8, my lord, page 57, my lord. I'll show that what they have done, my lord. And who is the order which under challenge, my lord?
Item 38. Item 38.
Now the question is, who is appearing for a contempt now? Contempt. You are appearing? Yes, please come. My first jurisdiction is the contempt. We need to close that. Where is your allegation that they are running on that?
My lord, I may just point out one thing. Certain facts have not been placed correctly. Perhaps my learned friend is not instructed properly. What has happened? That previously, that 107 which my lord has pointed out,
previously they were, on the basis of Rupan Talukdar, they approached this honorable court with a writ petition, challenging two orders which are dated.
No, 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 madam,
I'll-
madam, one minute.
Them.
You are the person who were allowed to run on Friday.
Yes, the Panchayat market to run on Friday.
No, no, that is the, on the basis of the order dated 35, 2025.
No.
That was stayed.
3595 is, sir, please. Okay. Sorry, I'm sorry. 35, little bit of disturbance.
It's okay. Please.
35 2025 order was obtained suppressing the writ petition which my learned friend on the other side is appearing, item number 36. This fact was suppressed that two orders which I was trying to point out now passed by the speaking order passed by the deputy commissioner with a challenge in writ petition number 4139, and this honorable court, without interfering with that order, said that under new 107 you need to get approval from the government, and therefore this honorable court in 4139 said you go to the government and file representation. They went and filed representation before the government, and the government passed a speaking order dated 39/2024, and challenging that they came with the present writ petition where my learned friend is appearing now, item number 36. This honorable court did not stay the order, and while this writ petition was pending, without, I don't want to use the word suppression, without pointing out that there is a writ petition pending, they approached the deputy commissioner, and there was another market going on there in the deputy commissioner's office, I believe, and this 35/2025 order was passed. Now, then I challenged the 35/2025 petition in this, and that time, since the Jaleshwar Anchalik Panchayat, my lord knows that there was no elections for a long time, and the previous body had, I was just taking care of the Jaleshwar Anchalik Panchayat market. That market does not belong to me. The question of locus came out. But when it was pointed out that those two orders passed by the deputy commissioner, not interfered with by this honorable court in 4139, and thereafter relegated to the Panchayat department, the state government passes an order, and the district development commissioner reviews the order of the state government, and that too, they approach the writ petitioner through some MLA, whatever, I don't need to say that, and this order which I have impugned. Now, since there is a question of locus, and I was only during a transitionary period, my learned friend, Mr. Bora, my lord, he has come up with since it's a market of the Jaleshwar Anchalik Panchayat, he has come up with a writ petition, since whatever this question remains to be answered, to challenging the 35/2025 order.
Now tell me, from this photograph, the DC says that there is no, running of the cattle market on Friday.
Yes, now coming to the contempt petition, my lord.
First, in your original contempt petition, there was no a single averment that on Friday they were running. Now, in the additional affidavit, you say that on 8/8/2025 they were running, isn't it?
It was continuous, my lord. I'll point out.
And how can it be a continuous?
My lord, I'll point out from the petition, my lord.
No, madam, you have to understand that contempt has to be specific.
I understand.
So where is the specific thing, unless you have stated only in the additional affidavit?
Even in the main petition, my lord.
No, where is the main petition they have stated?
In the main petition, I have stated in paragraph 7, my lord.
Yes, what do you say? Yes.
That in the morning of 20th of June 2025 at about 10 a.m., the petitioners, that's a Friday, my lord. The petitioners, upon noticing setting up and operating the cattle market, informed the office of the district commissioner, respondent number 3 again. But no effective action was taken to stop the violation, and the market continued to function openly and in blatant disregard of this honorable court's order. And my lord, I may also point out, my lord.
How did you approach?
I approached with the copy of the order, my lord.
How? Where is your representation? Where is the date that they were operating on that?
My lord, I have said it that on, huh? Yeah, I understand it. Uh, and paragraph 6, I have said that despite the express restraint contained in the order dated 18 June, the respondent number 5 willfully, deliberately, and contumaciously defied the directions passed by this honorable court and operated the cattle market on 20th June 2005, that is immediate the next Friday. And my lord, I may point out one thing. This is a contempt petition and it is between the court and the contemner. I am aware of this. What I am trying to point out that
The question is when there are disputed questions or when the state is not involved out there, this court normally would not issue a contempt notice even.
Yes, yes, exactly, my lord. What happened, my lord? That 4139 petition, they were relegated. They came with this present writ petition. That writ petition,
You're dropping the contempt.
my lord, I leave it to this honorable court, but
Dropping the contempt. However, we pass certain directions. Till it is not being completed, as regards the order, we'll take it up again. We don't have the time for that today, but we'll look in contempt.
and they were appearing through a caveat, my lord, assisted by a senior counsel. We also have a duty to the court. If an order is passed I'm appearing through a caveat, some restraint order is there. It is my duty also to convey to my client that this is the order, you cannot operate.
Yeah, you're not running, no?
No, my lord.
On Friday?
That's why we filed it every, no.
Takes 24.
We're not running. That is our grievance. That's why we filed it. I am, my lord.
My lord, this is 24.
I make.
Transaction receipt is there.
Wait. So I close this contempt.
It's okay. I leave
You
it
of
to
the what Mr. Kane Chaudhary, the learned senior counsel, stays on instructions of Ms. R. Chaudhary and further directing the till the disposal of this petition, which we will take it up next week. We don't ask the DC not to do it, not to allow. No. Intimate more clearly today. Not to allow any more cattle trading out there in these markets on Friday.
And my learned senior friend is making a statement. It's okay. The contempt is being closed. There's a transaction receipt and I have in the main contempt petition. And there's a photo of
How do I know that it is on 30th?
My lord, the date
28th.
is there in the transaction receipt on page 24
So that prove it.
on 20th of June.
Prove it. Bring that person who has signed it. How do I know it?
My lord, it's okay. It's a content matter.
Don't
It's
come
okay.
up with this.
It's a content.
When it is with the state,
Yeah,
it can be done.
It's okay.
Otherwise, unnecessarily when
Correct.
the instant contempt application has been filed, challenging and alleging willful and deliberate violation of the order dated 18/6/2025, passed in WPC number 3389/2025. It is seen that pursuant to order passed by this court on 8/9/2025, WPC number 3389/2025 have been also tagged along with the instant contempt application. The learned counsel, on behalf of the respondent number 5 in WPC number 3389/2025, Mr. Kane Chaudhary, learned senior counsel, assisted by Mrs. R. Chaudhary, appears, and they submit that there is no violation to the order. And it is under such circumstances they have filed an application being IA number. Which one?
Once I'm giving the number.
2433/2025.
2433 of 2025.
Seeking vacation of the order dated 18/6/2025.
Yes.
This court also inquired with Miss Udas, the learned additional senior government advocate, who all appears on behalf of the district commissioner, Walpara. So the learned additional senior government advocate further submits that there has been that the deputy commissioner have duly instructed not to carry out any work, the run the cattle market in view of the order dated 18/6/2025 in WPC number 3389/2025. So taking into account the above, this court therefore drops the instant contempt proceedings. This court further directs the district commissioner, Walpara, not to permit the not to permit any cattle market on Fridays. On Fridays at what is that place? At Borunagar, Damri Bhasa, Bridge Tiniali Paksuhat. Till the interim orders passed in WPC number 3389/2025 has been it's in operation. Contempt proceedings accordingly stands dropped. The main which is the lead matter.
Will not, will be too much if I ask for Wednesday or Thursday.
Yes, I'll do it. I'll take it as item 1.
Yes.
Because it's so much of fighting we need to complete. And Mr. Chaudhary, we don't get also the pleasure of hearing Mr. Pran Bora all the time.
No. Only thing is that why so bias regarding some of the Friday is concerned. Why he want to is a market which has to be run on a Friday. That's the thing.
We'll have it on the which is the lead matter? 237?
237.
237. 237 and logot hey baki kita likhi. Lease this court have duly heard the learned counsels appearing on behalf of the parties in the present batch of writ petition, as well as also the interlocutory applications. So taking into account that there are interim orders which are in operation, this court fixes the matter on 25th of September 2025 at 10:30 a.m. An attempt shall be made to dispose of those petitions on the next day. The interim orders passed in the batch of repetitions shall continue till the next day.
My lord, subject to the consent, my lord, and can it be on 24th?
No. 24th, so many.
A little, I'm not available on 25th.
Okay, 24th, how many matter? 24th, you see, the problem is this.
26th.
This will take some time. You see, these are all motion days given. And I'm taking the lead bench for. Otherwise, you have to wait. Somebody has to wait. But we can have it after vacation.
Either 24th,
No,
24th.
let it be let us try on 25th.
24th of
24th more apotti nahi, photo.
or na gom thake thake.
Okay, 24th.
25th. Or 24th, any day.
24th at 10:30.
Yes.
I'm great.
Okay, any more matter to be taken?
Okay, items 45, 46, 47, contempt matter.
What is it?
Any date may be fixed.
Date Lulu. Yes, Mr. Chaudhary, what is there?
Item 40.
Yes, Mr. Chaudhary.
Item 40 is a short matter. Your lordship may dispose of within by short order, my.
Which one?
Item 40, my.
What is it? What matter is that?
That is, my lord, the fishery, my lord, that was delayed handing over.
Delay lordship. Delay in possession.
Delayed handing over, my lord.
We know in a-
And my learned friend has been agreeing, my lord. I have seen in other order, other petitions, my lord. There are two prayers, of course.
next delay, we delay in possession, we give lordship.
This one? You have filed the affidavit?
No, affidavit
No,
has
lord.
not been filed.
He's asking for remission, I suppose.
Remission.
That part, my lord, your
Remission,
lordship
he is not-
direct them to consider, my lord, that part.
He's saying that he will
No,
not.
no, I don't allow these people to consider. They don't have. this-
They are with
Too
us.
much faith on consideration unless I want to show that, okay, I need one more disposal for a day and pass an order. Okay.
Well,
Which
right.
I-
Okay. They are with.
You are entitled to, you will get it. And I have only passed, I think, 6 or 7 in my 4 years of career for consideration.
I know that.
No, lordship, it's okay. If they are with us till 2030, lordship.
Yeah, they are 2030.
30. So,
Okay, no problem. Okay, we can have it after vacation.
My lord.
Mr. P. Sharma, the learned standing counsel of the year admits that a final opportunity may be granted to the respondent numbers 1, 2, 4, and 6 to file their affidavit. Also, list this matter again on 10th of November 2025. Also, the affidavit be filed on behalf of the state respondents on or before 3rd of November 2025.
file your presence.